May I please,
Morning.
Lordship? May I please, Your Lordship?
1 second, let me just settle down. Yes, please.
May I please, Your Lordship? I beg to mention item number 14. Lordship, we would like to withdraw the matter. We have received instructions from our client that the issues have been settled by both the parties.
In the mediation,
Yes, Lordship.
give me the file.
I think 14.
14.
Rupali Mohan.
You are there in 14?
I'm there. I'm for the issue.
Because I think it is with mediation report. That is why I wanted to check the file.
Yes.
So the matters have been settled in the mediation.
Yes,
I'm not sure, but I was. Right.
Heard MS.
B. Shaha.
B. Saha, learned counsel appearing for the petitioner. Also heard Mr. D. Bhattacharya,
Sure.
learned counsel appearing for
Respondent 5.
respondent number 5. M. Bhattacharya for respondent number 1. MS so-and-so, learned counsel for the petitioner, submits that she has received instructions from the petitioner that since the issue involved in the writ petition has already been settled by the Accountant General Government of Assam, the petitioner does not wish to press the petition further and accordingly requested for withdrawal of the same. It has also come to the notice of the court that this matter was sent to the mediation center and the petitioner has also informed the mediator as regards the matter being amicably settled prior to the mediation. In view of the above, the writ petition stands dismissed on the withdrawn. Yes, Mr. Dubey?
But as regard item 22, my friend Mr. Singh was supposed to make a mention. He's stuck up in traffic.
Yes, even I was stuck in traffic. I can empathize the situation. Yes, what do you want? Tell me, Mr.
But in
Dubey.
fact, I am for the petitioner, Lord.
Hmm.
And Lord, in this case, FCI has engaged senior counsel Mr. Chaudhary,
Hmm.
who has some difficulty in arguing the matter today.
Hmm. When do you want it?
Lord, on 23rd of October. Lord.
Okay. As jointly prayed by the councils, relist on such and such date.
23rd of.
Lordship, I beg to mention item 34 of the daily list. Lordship, Council Mr. UK Deca has some difficulties today. Lordship, may kindly 34. Lordship, may kindly adjourn the matter for the day and list it after Puja vacation.
As prayed for by Mr.
Lordship, I am appearing for the respondent's Lordship. Actually, so far as my knowledge goes, Lordship, because of pendency of the risk petition, Lordship, then nothing could be finalized, Lordship. His service benefits could not be released. We are admitting and we are already on the process of releasing this,
Then-
Lordship.
And I will have.
On last option also,
I
there's
got this
no time.
instruction from UK Deca.
All right, you inform
I
Mr.
will inform-
Deka about the information that has now been given by, because if the issue involves, but this is dismissal from service.
Yes, Lordship, but everything has been processed in the department itself, Lordship. So there is a particular statement from the deponent, Lordship.
All right, next week,
Lordship.
as prayed for by Mr.
Pikatonia.
So-and-so, learned counsel appearing for the petitioner, relist on release next week on a date to be fixed by the registry.
Deeply obliged, Lordship.
May I please, Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 25, Lordship. My senior Miss A. Gayan has some personal difficulty, Lordship.
20?
25, Lordship.
Yes. Who's your senior? You're for the petitioner
I'm for the response.
and petitioner. Any objection? As prayed for by MS P. Rabha. E. Rabha, on behalf of MS A. Gayan, learned counsel appearing for respondent numbers 1 to 5, which is not opposed by the other side. Relist after 2 weeks.
Next week, my lord.
Relist. Oh, this is relist next week on a date to be fixed by the registry.
Okay.
For reference to mediation, item number 1.
Agreeable? Agreeable?
Yes.
All right. Give your names, huh?
First one. Item number 2.
Agreeable?
Yes.
Respondent, who's there?
Respondent NF
Hmm?
Mm.
Central government, anyone?
Central government and NF
Central government, anyone? These central government councils are never here. Yesterday also there were so many times that this court has to keep waiting.
Otherwise, today it's very thin. It's heavy.
All right, I'll then have it after some time.
Everywhere water logging.
All right, I have also faced the same situation, so that's all right. That can be understood. Yes, Ms. Counsel, you try and have someone from the central government, then I shall pass the order because their consent is also required before I send it for mediation. Okay, so just try and see if you can get hold of someone from the central government. Yes.
Item 3.
I am there for 3 minutes, but petitioner is not.
Time being. Right, we're having, we're keeping all these matters where one party is not there as time being for the moment.
Item 4.
Agreeable.
Lordship, I am for the respondent idea, Lordship.
Here also petitioner not there. All right, wait for some.
On the last occasion also he was not there.
Hmm?
On the last occasion also.
We'll wait for some more
Lordship,
time.
Lordship.
Today is an
Yes,
exceptional
yes,
day.
yes, yes. I could somehow manage to come.
Yes.
Item 5. Okay.
Maybe also. So this matter is actually maybe closed lawsuit because the settlement has. been done.
Agreeable, close, not agreeable, adjournment.
Actually, what happened yesterday, previously it was already in mediation, it was already failed, but it's need for hearings.
So you don't.
Actually, Lordship, we are paying.
There's one thing is there.
Now I don't want you both to enter into some kind of dialogue here. Huh?
Okay, okay, fine. Yes, fine.
You're addressing the court here. Please be mindful where you are addressing. Not agreeable. Please give your dates. Yes, next.
Item 6.
I am there, but.
Yes, but other side.
Item 7 to 9.
Here, my lord, I would like to take instruction on behalf of application.
Instructions. And otherwise, are you agreeable?
No, my lord.
You're not agreeable.
Not agreeable.
So then what is the use of taking instructions? Not agreeable. All right.
Okay.
Give your names.
Supplementary list item number 36.
$36.
6.
A2 mediation. Huh?
Well,
Next matter.
37.
Next matter.
38.
Time being. Other side is not there. একদম লাষ্টত মাৰি দিব কাৰণ মাজে মাজে মাৰি থাকিলে দিগদাৰ হৈ যায়
For admission, item number 10 to 30.
Legal lordship. Lordship, my senior is on legs. After some time, your lordship. We would like to argue this matter today, your lordship.
Mr. Das,
After some time.
But some of the court time may be stuck up, but that your lordship will.
you both have a word, the juniors, and come at a time where both the seniors are available before this.
I feel bad because the court is also.
It's all right. It's all right. So this court is giving you that accommodation. So get a time, which time you all can be, all the seniors can be together available before this court, and this court shall take it up. Just ensure that your juniors indicate it to the court master. All right?
Item 15.
But in this matter, my lord, I was to produce updated instruction matter.
What does your instruction say, Mr. Das?
Instruction says that, my lord, the auditing is being done,
Hmm.
and the auditing for the year 2016-17
Hmm.
and 17-18 are to be completed within 2 months, my lord. The matter may be posted after vacation, my lord, in the month of November, my lord.
For 15-16 reflects a cash difference.
Yes.
But where does it say about the other?
This, my lord, the second para, my lord. The internal and statutory audits for the financial year 16-17 and 17-18.
Are in progress. Yes, so we'll adjourn it.
Yes, Lord, that will be better.
Heard Mr. B. Sharma, Learned Counsel for the petitioner. Also heard Mr. S. Das, Learned Standing Counsel, ASIDC. Chalia is there today? Anyone from finance? Tough. Mr. S. Das, Learned Standing Counsel, ASIDC, places the instruction received by letter dated 6/9/2025, indicating the up-to-date instruction as called for, wherefrom it appears that the internal and statutory audits, wherefrom it appears that though the audit for the financial year 2015-16 is complete, however, the internal and statutory audits for the financial years 2016-17 and 2017-18 are currently in progress and are expected to be completed within 2 months based on confirmations from the auditors. Stop. In view of the aforesaid instruction placed before this court, let this matter be listed at a 2 months or episode date on such and such date, by which date it is expected that the audits for the aforesaid financial years are completed. Mr. So-and-so shall further, shall also place the up-to-date instruction of on the next date of listing. This you take it on record, mark it as X.
20.
20. I do.
Item number 16 to 21.
Martin, the episode. Petitioner, your petitioner for
Yes,
here.
I am for the petitioner and I am appearing for 21 item.
Huh?
Item number 20.
But what about the other petitioners? We'll wait for some time then.
Much of it.
Item number 23.
Yes, please, sir. No instruction has been received, my lord. Have a timely delivery.
I think wait for a while. The petitioner is not here. Every silo moment.
Item 24.
Write a comment after some time.
Item 26. Sorry, item 39. Wait, please.
This is yesterday's case, Mr.
Yes,
Kushgar. Yes, Mr. Dhar.
My lord, I am very much ready with all judgments, my lord. My lord, a similar case, once it came up before our High Court in Imphal bench. High Court passed an order on behalf of the petitioner. It went to Supreme Court, my lord. Supreme Court restrained and gave a direction, my lord.
Give
And
me
that
that.
is-
But otherwise also, you see, the object of compassionate appointment being immediacy, whether the some other authority is now saying no or whatever, without even going to that aspect, perhaps this writ petition is unmaintainable.
No.
Because at the end of the day, what the writ petitioner is seeking is compassionate appointment. Correct?
My lord, my lord.
That prayer of the writ petitioner is not maintainable in view of Dibabrata Tiwari.
My lord,
Though
very
he is saying that yes, DLC has recommended, right? And now it was supposed to be placed before the SLC, but instead of SLC, some other authority has rejected. This court need not go into that aspect. This is a writ court.
correct.
This is an equitable relief that
My-
he is seeking.
My lord.
This equity, in order to do equity, delay and correct.
Exactly, my lord.
So I think I was thinking of
My lord.
disposing it off in that fashion. So if you want to add something or give something, I will add it. Otherwise, I'm
My lord.
dismissing this writ petitioner, Mr.
No.
Khandikar. There is no
My-
case. Your
my-
delay.
No, my lord,
Hmm.
my case is, my lord, since I have been recommended. So it is the duty.
I've heard that. I'll deal with it.
Even-
I've heard that that is your submission, that since you've been recommended, it was the SLC who should have considered.
My lord,
Correct.
2 days back, my lord, a series of cases has been done. I am having this order, my lord. In these cases, the submission of the learned Advocate General was that all the compassionate appointment pending application will be considered. And this judgment has been.
No, but this is not in your case, it is already been dismissed
My
by
lord.
an authority.
No, he is not the competent.
Correct, whatever, but this court division, this does not, is not
But
going to go into that.
Even rejected, this judgment is covered my case, my lord.
All right, I will have a look at it. 1 second. This para 11 also takes care of that minor thing.
Yes, ma'am. That is why, my lord, I got it, my lord. And this was from our High Court only in infal bench.
This is the decision you want to rely, Mr. Kondikar?
No, my lord.
I want to
No, my lord.
rely, my lord, WBC number 342.
This, Mr. Dhar, you have given.
Yes, my lord. This is the judgment, my lord, passed by our coordinate bench of our High Court, and this Supreme Court judgment was quoted and referred to, my lord.
After referring, the honorable.
1 second, 1 second. I'm not reading the judgment that you are giving.
My lord.
Why are you in such a hurry, Mr. Kondikar?
Sorry.
In this case also, at the time of the death of your mother, you were a minor.
I was mine.
And when did you become major?
My lord, after attaining major fee, I have filed application.
When did you attain majority?
2012 in the year 2021.
2021.
21.
After a long gap of almost 13 years.
Majority. And you applied on
2012, 21.
you applied.
I,
And majority is also 2012, 21. I thought yesterday you gave me that date.
yesterday I have given date 2012, 2020.
That is the date on
Application.
which you attain majority, or that is the date on which
Date
you
of
had,
application. Application.
which is when did you attain majority? Mr. Dhar, find out. Find out from the pleadings, Mr. Dhar.
My lord, if
I just want that date, Mr. Dhar.
Yeah.
When?
Well, after some time.
What after some time?
No,
Huh?
That he has not pleaded, my lord.
That is you're trying to make a case that at that time you're a minor, you don't even know when you attain majority. You may have attained majority in sometime in 2000 also, who knows?
My lord, if I go by affidavit, his age is 37 as
So
on
just find out by approximately by when he would have attained majority.
37. No, my lord, he was major at that time.
He was a major at
He
that
was a
time.
major. He became major in 2005. If I go by his affidavit, 37 years. So meaning thereby delay and laches, my lord.
Okay, fine.
His affidavit is in page number 23, 37 age.
So he should have been in the year 2008, he should have been about
It could have been about my lord, 21. And the biggest hurdle now, my lord, if it is so, my lord, in the writ petition, I can show only one thing.
one second. Yes, what is that decision you wanted to show?
My lord, this, my lord, the paragraph,
Anok.
Lord, here the honorable court says that.
Give me.
cases Filed before 3/4/2025, challenging the rejection are set aside.
In view of the consent, this is a consensuous order.
This is a common judgment.
Mr. Dhar, whether the writ petition, this present writ petition also comes under this?
Yes.
Let's have a look because,
Yeah, it was filed on, think from around 5th or 4th October
yes.
24.
And it says, and all the writ petitions, all applications which of a compassionate appointment submitted by the petitioner shall be considered and disposed of by concerned DLC, SLC on merit by taking into consideration the various guidelines prior to so and so, laid down by the so and so and so and so. Consequently, rejection of all compassionate appointments by DLC, SLC which have been put to challenge and are pending in the so and so as on so and so are set aside. And it says all the writ petitions that are pending as on today, that is 3/4/25, which have put to challenge the impugned OM. Is the impugned OM challenged in this writ petition? 18/9/24 is under challenge here?
Yes. Page 50, my lord. Challenge.
Yes, it is under challenge. my lord.
Hmm?
Under challenge.
Yes, under challenge. Yes, then is it covered? Find it out.
No, my lord. It is, if you go by that,
No, have a look at it. After I can take it up after the next matter. Just have a look at this judgment, because if it's covered, then we'll pass a similar order. Otherwise, I would have dismissed it because there was no merit in this case. the judge. Just have a look at it, Mr. Khanigar, after some time. Huh?
Typing item 24.
24 to Bhupesh Das, na?
Yes, Mr. Chaudhary?
Yes. My lord, this is a matter where lordship was pleased to deal with. If you recollect, there was a proceeding on the same charge where lordship was pleased to interfere with the disciplinary proceeding. However, my lord, the authorities have not brought the matter to the logical end, my lord.
Hmm.
If lordship would kindly come to your lordship's order,
Who's
At-
there on the other side?
take my lord. One party here.
Yes.
My lord will kindly come to page number 115, that's the judgment.
115.
Now, the operative portion is at page number 126, para 33 and 34. As noted above, para 33 and 34.
Yes.
As noted above, in the present case, the departmental proceeding and criminal cases are based on identical and similar set of facts. And the charge in the departmental case and the charge before the criminal court against the petitioner are also one and the same. The listed witness in the departmental case were examined in the criminal case, and criminal court, upon examination of such witness, has concluded that the prosecution has failed to establish that petitioner accused had demanded illegal gratification from the informant. That being so, in the considered opinion of this court, further continuance of the departmental proceeding against the petitioner is wholly unfair and unjustified. Accordingly, this court deems appropriate to dispose of the petition in the interest of justice by directing the respondent authorities to conclude the departmental proceeding which is pending against the petitioner in accordance with law, by keeping in mind the observations made herein above within a period of 1 month from the date of receipt of the certified copy of the
It is still not done.
Not done.
No, it's a case of contempt.
Precisely. And kindly see the lordship subsequent order. Please come to page 135 when they file an IA, my lord. This was the order your lordship passed.
Page.
Page 135. Operative portion of the order in the IA.
Mr. Nayak, you're appearing? Sorry, huh?
Lordship, I will be appearing on behalf of the United.
Mr. Nath is appearing.
United alleged in court for number 3, Lordship.
No, ask him to be here. Otherwise, I'm going to direct personal appearance. Yes.
Today,
Because
as per-
it appears prima facie the order of this court has still not been compliant. Yes.
I am reading the last paragraph
Yes,
at page
yes.
135. Today, when the matter was called for, Mr. D. Nath Lanes, Senior Additional Senior Government Advocate, submits on instruction that a further period of 3 months would be required to conclude the departmental proceeding. It appears that departmental proceeding against the respondent is pending for a long time, despite conclusion of the criminal trial resulting acquittal of the respondent. In the considered opinion of this court, the further period of 3 months in the context of the present case appears to be unreasonable, and as such, directs state respondents to conclude the departmental proceeding as directed earlier by this court strictly within a period of 1 month from today, failing which adverse consequences in accordance with law shall, if required, be faced with. Now, my lord, what they did not conclude the proceeding. Instead, my lord, they issued this order at 137. They have again appointed an inquiry officer, as if lordship has permitted that.
Now you have challenged this.
Yes, this order is stayed. Whereas an inquiry under Rule 9 of the Assam Services Discipline Appeal Rule is being held. in
Today
respect-
this matter has come for what? For admission.
for admission. No, it was hard at some length, my lord, by different coordinate benches.
And the pleadings have,
Basically,
they have filed their
They
affidavit.
have, yes, Lord, they have also filed a writ appeal with delay against your lordship's order. But my lord, that will take its own course.
There is no
that-
stay there.
There's no stay. Now, what they have done now, my lord, they have appointed another inquiry officer.
Now, this the fresh inquiry that they have appointed.
Yes.
Now, this is then this means that first of all, the first inquiry, which was supposed to be, which is directed to be
Concluded.
taken to the logical conclusion, was not done.
Not done.
Correct.
Yes.
Instead of that, they have appointed
A fresh inquiry.
a fresh
Under the
inquiry.
fresh inquiry by a fresh inquiry officer.
And what is the reasons? Let us see.
Kindly see, my lord. Whereas an inquiry under Rule 9 of the Assam Services Disciplinary Appeal Rule is being held in respect of the charges framed against Bhupesh Chandra Das, ACS Joint Secretary, so and so, so and so. Whereas Monimala Fukan Borthakur IS, the then State Inquiry Officer, was appointed as inquiry officer to hold an inquiry into the charges against Bhupesh Chandra Das by notification dated 2/8/18. Whereas Monimala Fukan Borthakur retired and Srimati Atika Sultana IS, the then State Inquiry Officer, was submitting the inquiry report by dated so and so. Whereas disciplinary authorities of the opinion that further inquiry is needed in this case on the ground that some serious defects crept into the previous inquiry from the stage of recording evidence and statement of important witnesses listed in the show cause notice were not recorded by the inquiry officer, and also considering the fact that Atika Sultana.
Mr. Nath,
Lordship.
prima facie, this court is of the opinion that somehow the state government is trying to circumvent the orders passed by this court.
Yes.
But,
What is this? Because you see, this court has given a clear verdict where the court found that since there is a clear acquittal, the same charges, you may have a grievance. You may take it to prefer all your appeal remedies to the top court. That is a different issue. But as far as the order of this court stands, there is no way out. Now it seems that since you could not do anything else, you found another way by which now you're doing a fresh inquiry. In short, it is a circumvention of the orders passed by this court, and what else?
Lordship may kindly consider, Lordship.
Yes.
An appeal has been, the authority have taken a decision to prefer an appeal. Appeal has been filed.
That's all
Lord-
right.
Lord-
Is there a stay?
And no, notice in the.
Is there a stay?
No, stay as on today.
Yes.
And the notice has gone in the condonation.
That is all right.
Lord,
You have filed an
as regard-
appeal with condonation, notice is gone in condonation, that is all right.
Lord,
Is there a stay of this court's order?
no, as on today, it is not there. My lord, as regard the steps taken, my lord, Lordship has already passed an interim Lordship has already in this case passed an interim order, my lord, it is there. And Lordship has protected the petitioner. So far, my my lord, the matter has come up today
For admission?
for consideration of the, in the meantime, my lord, there is a my lord,
There's another angle to it.
there is a.
My name is required to be sent to the IS for nomination. That they have not done.
Only for that purpose.
There is a IA also.
Yes.
Lordship, that has come, Lord.
So
No, my lord, IA is, no, it's not that IA has come, the whole case has come. Anyway,
That's true, but the
No,
understanding.
what is there before this court today?
no, my lord, the court, what had happened, my lord, they have filed an affidavit in the reputation where this honorable court, along with the aspect of my lord's second inquiry, was also considering my nomination to IS. It is in that context, orders were passed from time to time. Eventually, my lord, they have taken a stand that since under the regulation of 1955 there is a provision for provisional, nomination. My case is, my lord, that provisional nomination should be done subject to outcome.
Why not considering that
Yes,
there is a
yes.
provision?
That, my lord, I have spoken to them and I am told that his name has been forwarded.
That
No,
means
no,
he's
no. Yes,
being
yes,
considered.
Yes, his
So I
name
can record that
Yes,
submission
yes,
of
yes,
yours.
record that.
yes, that instruction I have spoken to I have spoken to, I have spoken.
All right, that I shall record. Anything else?
His name.
I think in that case, we can have
Yes,
this matter.
yes.
But otherwise.
No, yes, that way, my lord, but it's not that it has been done, my lord.
His name has been forwarded, my lord, that is my
We
information.
can record
Yes, yes,
the submissions of Mr.
Yes,
Nath.
Yes.
So that is the aspect, my lord, which has come, my lord, to my understanding today. So that information kindly record and lordship may give the matter for final hearing, my lord, on another.
Pleadings are completed, Mr.
Yes.
Chaudhary?
Yes, yes.
Then I'll admit it and post it for hearing.
Yes, yes. Admission hearing, my lord.
Admission hearing, we'll admit it and post it for hearing.
Yes,
We'll give you a date
yes.
in the month of November.
No.
Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Kashyap. T. Kashyap, right? Learned Counsel appearing for the petition. Stop.
Yes.
Also heard Mr. D. Nath, Learned Senior Government Advocate, Assam for the state respondent. Stop. Mr. Nath
E.
submits.
Take on.
You have that instruction?
Telephonic.
Submits on instruction
That the name of the petition has been forwarded.
that the name of the petitioner has been forwarded
Not.
forwarded to the Indian forwarded to
UPSC.
forwarded to UPSC along with the others as per some provisional something you said that is not required. So and so, huh? Stop. Okay. All right, stop. It further appears that pleadings are complete. Matter requires full-fledged hearing. Admit no formal notice as parties are represented. Relist for hearing in the month of November. Any date?
That will give a date.
November, the date on such and such date.
18 November.
Not.
18 November, Mr. Chaudhary, you are
Not-
here?
Either 3 days before or after.
Wait up. I think is that holiday. 18th, I think is a holiday,
Let it
right?
be
Before
on-
that or after that?
Let it be on 25th.
Will it be on 13th, my lord? 13th.
On 20.
My lord, under Indian Administrative Service Recruitment Rules 1954.
Did I say that?
Yes.
As per the provisions contained in the
My lord, the
My-
Indian Administrative Service Recruitment Rule 1954, read with Regulation 9(1) of the Indian Administrative Service Appointment by Promotion Regulation 1955.
No, my
Mr. Kashyap, just give
my
it in a
instruction
chit.
is not, my instruction is.
It will
that
be as per
name-
that.
Name has been forwarded along with the others, not as per the rules and all these things, but that my
No,
telephone.
no, it has to be sent under the rules
Then
only.
it is as per the, along with others. That is not.
It has to be in accordance with law, right,
Yes,
Mr.
yes.
Nath? Then you
I'm not
say
saying
that,
that. Along with
Got
others.
Kopa, that Mr. K.N. Chaudhary, Learned Senior Counsel submits that the name of the petitioner ought to have been provisionally
Nominated.
sent
Yes.
as per the provisions contained in so and so act. Okay?
As per
Mr.
regulation of 1955, that regulation.
Mr. Kashyap, just give that name.
Yes, yes.
Mr. D. Nath submits that as per the instructions received, the name of the petitioner along with others have already been sent to the sent to where?
Sent to the UPSC along with others.
I've already said others.
Lordship, this is my telephonic instruction, kindly.
Okay, I have only recorded the
Lordship.
telephonic instruction
Lordship.
which you have received.
Lordship.
Both of you are happy now?
I just 40, 41.
Here, my lord, we have filed affidavit on 10/9/25
Hmm?
in item number, these are connected matters.
This is
41
which one?
41, we have filed affidavit on 10.
Supplementary.
Item 41.
10/9/25, we have filed a affidavit, my lord. If my friend, my lord, wants to file a reply, my lord, fine, otherwise, my lord will fix it for when we can hear him, my lord.
Are you filing a reply?
No. man. My lord,
What is the issue?
my lord, it's something important, my lord. Kindly take, my lord, item 40, my lord. 41, my lord, WPC 3172.
The option.
My lord, thing is that, my lord,
Into list of her. Eight, na?
my lord, first of all, before going to the record, my lord, kindly I brief, my lord, on 6/10/2023, the government of Assam through its board, my lord, recruitment board, made an advertisement for appointment and selection and appointment of 5,563 posts for various, my lord, armed branch, unarmed branch, and many other PROs and my lord, APROs, many things, my lord. On the basis of that, with the petitioners before your lordship, in both the petitions are 200 petitioners before your lordship. As per the guidelines and clause of the advertisement, my lord, kindly come to page 49. my lord.
Yes.
49, this is the, my lord, the posts of, so-and-so posts of 5563 posts, my lord, and some distribution of posts again among various categories. Then, my lord, details of vacancies, clause 1, my lord. Roman 1.
Yes.
Roman 1B, my lord, then AB, VA, my lord. The armed branch, unarmed branch, there are categorization and regarding, my lord, reservation of seats, my lord. Then, my lord, kindly turn to page 51, my lord. See note Roman 2, my lord.
Yes.
District-wise allocation of vacancies of constables UB unarmed branch and constable armed branch will be made based on population ratio as per census of 2011. My lord, then my lord, come to next page, my lord, 52, physical standards, medical standard, all these things, my lord. Then, my lord, kindly come to page 56, my lord. We have undergone
What is the issue?
issue, my lord. Main issue is that, my lord. Number one issue is that it is clause 12, my lord. Kindly see to my lord, clause 12(5). Come to it, my lord.
Please just indicate what is the issue, what
Issue
is the
that, my lord,
challenge?
after being passed physical test, PST and physical examination, physical test and medical test, after passing this, the candidates will be called for written test, and the test will be called for as per my lord, will be called for 1:5. Against one post, 5 candidates will be called
For written test.
for written test. That is, my lord, clause 12, Roman 12, sub clause 1.
Now what has happened?
Now what has happened, my lord? After long time, they have given the result. Result is given individually, my lord. Only I can come to know my result by placing my number and date of birth.
This matter will require hearing.
My lord,
Pleadings are complete.
but my lord, the only my lord, instruction is that they are going to appoint within last coming 7 days or 10 days. My lord.
There is no,
That's the main instruction.
the matter is only come for admission today. First day, you have not taken any stay or anything.
My lord, at that stage,
The matter would require a full-fledged hearing. I cannot grant you that relief without hearing properly.
rightly, my lord, right.
The matter is only listed
But-
today
but-
for admission.
But thing is that
All matters cannot be disposed of at the admission
yes, my lord,
stage.
correct, my lord.
Yes.
My lord, thing is that, my lord, they are going to appoint very shortly. It was very shortly as per our reliable source, my lord. They are going to within 10 days or.
Mr. Dhar, when can we have this for hearing?
My lord will take it up any day, my lord.
When?
Next week.
Heard Mr.
AK Talukdar, my lord.
A.K. Talukdar, learned counsel for the petitioner. Also heard Mr. R. Thor, learned so and so. It appears that though affidavit in opposition, it appears that the affidavit in opposition for the state has already been filed. However, Mr. Talukdar submits that he has received instructions not to file any rejoinder to the affidavit in opposition.
In the second case, my lord. First case I have filed already.
Submits that he has filed rejoinder in WPC 1902 of 2025.
Yes.
However, he has instructions not to file any rejoinder against the
And
affidavit in
one-
opposition
one-
filed in WPC 3172 of
And my
2025.
lord, small prayer, my lord. This may be taken as affidavit filed in both the cases.
He further submits that the affidavit filed in so and so shall also cover the cover the reply in so and so. The matter requires full-fledged hearing. Admit no formal notice. Relist for hearing
Short
at
date,
a
kindly.
date deduct.
My lord, short date, my lord, they are going to appoint, my lord, and then we have to make party 5,000 plus, my lord. It will be near to impossible, my lord. My lord,
Before.
my lord,
Actually,
it will be over.
give-
Everything will be
give
over,
it
my lord.
before the
My lord,
vacation.
my landlord is saying next
All
week.
right, before vacation.
My lord,
23rd I have.
Next week, did you?
my lord, my lord,
25th.
my lord,
25th.
25th, my lord. 24th, my lord, I have some difficulties. Maybe on 24th, my lord.
24th?
My lord, my endeavor will be made to, my lord.
All right, next.
Kindly, my lord, maybe record other.
Next.
42.
Oblige, my lord.
Also, in this case, state examiner are supposed to file their affidavit, lordship.
Yes.
Here, I'm praying for some more time, madam.
Why?
No, the instruction is not yet received, madam.
As prayed for by Mr.
NJ.
NJ Khatonia, no? Khatonia, also Mr. Sharma, you also?
Accountant General, my role is completed.
Relist on after 2 weeks?
Yes, madam.
After 2 weeks on a date to be fixed by the registry to enable the respondent file return in the matter. Mr. B. Sharma,
Yes, for the accountant general, we have already sanctioned the GPF amount. Madam.
who Leonard Standing Counsel AG submits that the GPF amount has already been sanctioned.
Oblige.
That being item number 2.
Do you have referral again? It will referral. Do we bhagava kudlo? Agreeable?
Oh, my lord.
Hmm?
Sir,
Not agreeable.
Lordship, since she has been receiving pension.
But you said you were agreeable, na?
Yes, my lord.
So in item number 2, not agreeable, but AG Chaudhary, right? MSAG.
SB Chaudhary.
SB Chaudhary. MSSB Chaudhary, Learned Counsel of the petitioner, submits that that the petitioner is agreeable. Hetu bhagave janibo, huh? Please, naam gita di dibo. All right. Not agreeable.
For hearing item number 26.
B debiye mane not agreeably korse. Item number
26.
Yes, Mr. Chaudhary.
This is. But
Lordship, in this matter, hearing once has already was over, lordship. It was reserved and it was released after 1 year or more.
It has suddenly come today.
Yes, lordship, that is the issue.
You want another date?
I am ready, madam.
Mr. Nayak seems it is fair.
It was heard almost 2 years back.
So that is why I said it is fair. The request is fair. All right, when can we have it? Give a consent date.
After vacation.
All right, you come up with your date. Let me just start the order. You keep the date ready. Heard Mr. R. Chaudhary, Learned Counsel, Learned Senior Counsel, assisted by Mr. Chauhan. Na? R. Chauhan, Learned Counsel, appearing for the petitioner. Also heard Mr. P. Nayak, Learned Additional Advocate General for the state respondent. Stop. Mr. Nayak submits that since the matter has suddenly been listed today after being reserved from CAV by another coordinate bench, some accommodation may kindly be, the matter may be taken up on any other date. Relist on such and such date.
30th of October.
I am a so-and-so for respondent message. Yes, what is, which date?
30th of October.
Pala, Harry?
Madam,
Yes, yes.
may I make a request in respect to similar situation?
Hmm.
In fact, I had prepared this one.
Huh.
But item 30, that is also a similar situation. I heard 2 years back, it has suddenly come up. So
So this also after being.
let
huh?
it be on any other
No,
day.
but this
because-
has also been released.
Well,
All right, the same thing, but yet to me, as prayed for will equitable. And who's appearing for the other side?
Yeah, my lord.
Here, S. Nath will appear, lordship.
So,
Leading counsel.
all right, so I'll have his name.
Can it be on 4th or 6th of November?
Both parties record করার পিছত, it is submitted at the bar will equate, huh? Then released on such a date. All right.
Oblige.
Item number 29.
Even my lord, I am submitting before my lord one order. It is disposed of on 10/9/25. Whereas the father of the petitioner died in 2002. Yet it's same order, so it is also covered under the way. And my lord, even for covering, for considering our cases, the government also issued notification inviting our details, the pending cases.
No, in this case, it is to place before the next SLC. This yesterday, even I had disposed one case in that manner. That is all right. In your case, it has already been rejected by another authority. What is this notice?
Notice, my lord, invited in terms of order I have earlier given before my lord. They have invited the details of the persons who have filed cases.
So you have given or not?
I have given.
Which is, where is that you have given?
My lord, I have given the application only giving case number, saying the case is pending.
No, where is that you have given?
That application.
Ajay, yes, Mr. Dar.
My lord, let it go. If he has given, my lord,
Huh?
if he has already submitted.
Yes, that's what. And this order is also there. This has come after Dibabharata Tiwari. Now there is a consent, and as per that consent, it seems all
Yes.
petitions pending is on that date.
And yes, and those OMR's challenge. He has challenged
So those two conditions need to
condition
be
he fulfills. He
fulfilled, not any cases. Correct. Heard Mr. MR, na? MR Khandikar, Learned Counsel appearing for the writ petitioner. Also heard Mr. R. Dhor, Learned Standing Counsel, WPT and BC Department,
My lord.
appearing for the respondent numbers 1, 4, and 5, and MSM Bhattacharjee, Learned Additional Senior Government Advocate, appearing for the respondent numbers 2, 3, 6, and 7. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking compassionate appointment. No, the petitioner is assailing the impugned office memorandum dated 18/9/2024, issued by the respondent number 2, and the impugned order letter dated 13/4/2022, issued by the respondent number 3, wherein the decision and recommendation of the district level committee made in favor of the petitioner for appointment on compassionate ground has been rejected without placing the same before the state level committee within bracket SLC in violation of the decisions of this court held in the case of Hiranokuba SLC. Full stop. It is submitted at the bar. I'll say it is submitted at the bar only, that in the case of Abdul Qadir Bokshi versus the state of Assam and 4 others in WPC 342 of 2025, being the linked case wherein the coordinate bench of this court, by judgment and order dated 3/4/2025, in view of the consent, in view of the proposal made by the learned AG Assam to the effect that the state of Assam does not wish to press their challenge. No, don't say that. In view of the proposal made by the learned AG Assam and the consensus arrived between the parties, disposed of the writ petitions by directing that all the writ petitions that are pending as on today, I-3/4/2025, in the Guwahati High Court, which have put to challenge the impugned OM dated 18/9/2024, are to be decided as follows. 1, 2, তারপর কোট আনকোট করে লিখে দিবা। It appears that in the instant case also, there is a challenge put to the OM dated so and so. And the case of the petitioner is yet to be placed before the SLC. That being so, it further appears that the Deputy Secretary to the Government of Assam Personnel Department, Dispur, by notice dated, what is the date of the notice?
31st.
31st August 2025, invited in terms of the aforesaid order dated 3/4/2025, passed in Abdul Qadir Bakshi Supra, invited the petitioners who have challenged the office memorandum dated 18/9/2024, including those similar cases which has been disposed of by this court, citing the judgment and order dated 3/4/2025, passed by this court in Abdul Qadir Bakshi Supra, to submit documents / information in order to comply with the direction passed by this court in Abdul Qadir Bakshi Supra. Mr. So-and-so Khandikar, Learned Counsel for the petitioner, submits that pursuant to the aforesaid notice, the petitioner has already submitted application before the authorities. In view of the above, this court deems appropriate to dispose of this writ petition in the interest of justice, dispose of this writ petition by directing the
She has already approached their direction.
dispose of the instant writ petition by providing that in the event the petitioner has submitted the details as called for by the notice dated 31/8/2025, the respondent authority shall do the needful in accordance with as per the judgment of this court passed in Abdul Qadir Bakshi Supra. I think that is sufficient.
That is enough.
Ordered accordingly disposed of.
Already
Yes, next.
6-month time frame is given in that
Next.
order. My lord.
I am deep.
এইকেইটা থৈ দিব লাগিব এই OM-টো, হা এইকেইটা বস্তু মোক লাগিব। এইটো জাজমেণ্টৰ এটা কপি লৈ আনিবা, এইটো কম্পেশ্যনেট এপইণ্টমেণ্ট মাৰি এইখিনি লাগিব। এটা এইটো এক্স কৰি দিবা, কপি অফ দিছ কেপ্টন ৰেকৰ্ড নোটিছ, আৰু এটা কপি থৈ দিবা। Yes.
May I please your lordship? Lordship, due to severe water logging, my senior is indisposed today. Your lordship may kindly take up this matter on Tuesday.
Who's your senior?
HK Das, your lordship.
MS
B. Sekia.
B. Saikia, Learned Counsel for the petitioner, submits that due to the heavy shower and the consequential water artificial floods in the residential locality where where the arguing counsel, Mr.
HK Das.
H.K. Das resides, he is unable to attend the proceedings today. Mr. S. Bhuya and Mr. P.D. Nair, learned counsels appearing for the respondents, does not oppose to the adjournment as sought for. Relist when?
Tuesday, your lordship, 23.
I have some possibility.
Yes, come up, tell me a date.
Thursday.
Next Thursday?
Thursday, your lordship, actually, there is a little difficulty. My senior, yes, so that is why.
Next Tuesday? Next Tuesday.
Deeply obliged, your lordship.
Next Tuesday.
All right, you come, you give a date to the court master. Yes,
Deeply
next.
Obliged.
You all are very busy.
Sorry. I for the respondent number 5 school year.
We'll call again.
Item 31.
In this case, Girin Pegu is appearing for Union of India. He has taken consent from the other side for adjournment for the jail.
30?
1.
This way I shall have no work. Huh? 31. Yes.
31, my lord, I am appearing on behalf of D. Gogoi, my lord. He is the counsel for petitioner due to the rains, my lord, he could not.
Heard Mr.
Thakur.
I. Thakur, learned counsel for the petitioner, also heard MS. R. Devi, learned counsel for the respondent. Mr. Thakur submits, hey, agotoe kuriba. D. Gogoi কথাটো. And it opposed কৰাৰ কথাটো ক'ব নালাগে. Further, Mr. MS Devi also submit that Mr. G. Pegu, he's learned CGC, who's handling the matter brief for the respondent, is also having personal difficulty today. As such, relist when?
My lord, can it be listed this Thursday, my lord? This an
I
urgent.
think we are already having a lot of matters fixed Thursday. Eto date dibo Rupok. Sai pele di dibo. Next.
32.
Yes. Dismissal from service.
The matter of removal from service. Memo of charges. Memo of charges and page number 35, 6, 7, 8, 9, 40. Regarding memo of charges, he was charged on 2 counts.
Page number?
Annexure 3, page number 35. Type copy is also here. Type copy is at page 29, 30, 31, 32.
Yes.
Yeah. Charges are that number 1, that on 23rd, 12, 2003 at 2 p.m. complainant Dilip Gogoi is a private person. He lodged an FIR with the North Lakhimpur police station, alleging that his son appeared in an interview. And to manage the job of his son, the petitioner received rupees 35,000 on 2 counts. And that is the allegation. But
The petitioner was holding what post?
stenographer in the office of the superintendent of police,
Stenographer.
not Lakhimpur.
Yes.
So,
So
it-
that's the charge.
yeah, okay. And the police have registered the case under section 420 and 406 IPC. Again, the petition,
There's a criminal case.
criminal case, Lordship. Then another person, Nobo Kumar Fukon, he lost another FIR against the petitioner, alleging that the petitioner borrowed rupees 3,37,000 from him by executing an agreement to repay the amount. And when the amount was demanded by that informant, the petitioner issued a check. And on presentation of the check, that was dishonored.
This is a loan,
That is the allegation.
but it is a loan.
Loan.
The allegation is not
Loan.
bribe. The
Loan.
second allegation.
Loan from private person.
Only thing you did not return it back.
Not written, and I issued a check, but that was dishonored.
Yes.
That are, those are the allegations, and North Lakhimpur police registered two different criminal cases under section 420 and 406 IPC.
Yes.
Thereafter, during investigation, the petitioner was arrested, and on production before the learned citizen, he was remanded. Thereafter, he was bailed out. Then, during pendency of police investigation, the department has initiated this departmental proceeding by serving this memo of charges. Now, Lordship will see that entire allegation unrelated to his service, borrowing money from private person, and on assurance of managing a job.
No. First allegation is serious.
Yeah.
Taking bribe.
Not bribe.
What else then? Not bribe.
Not
That
bribe.
to get a
Not-
job.
Yes. Lordship.
Yes, read that first allegation.
Yes.
On
Yes, first allegation.
2312. Yes.
At 2 p.m., complainant Dilip Gogoi, son of Bholukon Gogoi of Borbari, Dihinia Gang, PS and District North Lakhimpur, lodged an FIR at North Lakhimpur PS to the effect that he appeared in the interview for the post of AB Constable in Assam Police in the year 2000. Then, in this connection, Devanand, the petitioner, took rupees 35,000 only from complainant Dilip Gogoi in two installments. It is on 7/4/2003, rupees 20, and on 4/7/20, by giving assurance of his appointment as AB Constable in Assam Police.
How can the stenographer in the SP office give the assurance to a candidate who appears in the interview of the job of a constable?
But
If this is not
This is
bribe,
the-
what is this?
this is
Anyway, this is the allegation. Yes, now what happened?
allegation that is.
It
I'm
is-
coming to what he abused before the Lamet trial court in the criminal case.
You see, Mr. Counsel, so in short, you are challenging the disciplinary proceedings, the inquiry
Yes,
report,
inquiry report.
and the infliction of the punishment.
Punishment.
That is the extreme punishment of removal. Correct?
Lord.
Now, this court has a very limited jurisdiction
Lord Chief.
when it comes to such matters, right?
Lord Chief.
This court is certainly not going to the sufficiency of evidence.
Lord Chief.
The question now is whether a fair inquiry has been done or not, whether all opportunities has been given to you or not. So you please come to that focus
Yeah.
point and show if there has been
One-
any
one more
procedural
point-
violations.
One more point, Lord Chief.
Yes.
I read whether over this subject matter, the charges, the disciplinary authority has jurisdiction to initiate this proceeding or not. That is one of my submission.
Why? It's not a misconduct if
No.
the stenographer is taking money, giving assurance of a job to a person who has sit in the interview in that office.
No, Lord Chief.
If this is not a bribe, then what is this? Who is that stenographer then?
Yeah.
How can he give this such an assurance?
Yes, Lord Chief. On the-
And
He
if the
was
disciplinary
acquitted.
authorities are has no power to then initiate?
No, Lordship. What he has deposed before the trial court is there. He has not paid the amount, but
That is all right.
allowed to carry the amount to pay
You
to
see-
some other
You see,
person.
that is why I'm saying that with those factors, this court cannot go into. These are the sufficiency of evidence.
Yeah,
Unless, of course, there is no evidence at all, then it is perverse.
Lordship.
Now, whether he has taken this money to give it to someone or the other, these are different things.
See, okay. Let's
Yes, where is the inquiry report?
Enquiry.
So
Lordship.
basically, there is no procedural violation.
Complete violation of.
Where? Show me what procedure violated. I've been asking you that.
Yeah.
Show what are the
Yeah.
procedural violations.
Added.
Let us be focused on the main issue.
Now. As per the allegations, they are reflected in the memo of pleasure. According to the disciplinary authority, that constitutes gross criminal misconduct.
Which page is that charge sheet?
Yeah. Page 36, Lordship. 36, first, second, third, fourth paragraph. Fourth paragraph. That your above note have constituted gross criminal misconduct and dereliction of duty and rendered you unfit to be retained in service. Those are unrelated to his service. How it can be dereliction?
Where are you reading, Mr. Counsel?
Page 36, Lordship.
Yes.
Paragraph number 4, first, second, third, fourth. Fourth, just for the last paragraph.
During investigation.
No, Lordship. Thereafter, another third.
Further you.
Lordship.
Yes.
Further, thereafter, further, you, unfortunately, these are the allegations. Then, thereafter, thus.
No, you read that. Why are you skipping all that?
Further, you, for the signature of.
No, 1 second. Mr. Counsel, start reading from during investigation.
During.
You see, you cannot just simply place 1 or 2 paragraphs which are in your favor. Let us see this charge sheet.
No. During investigation of the above mentioned cases, the IO also found that you have collected money from some other individuals, assuring them to give job in police department. You also issued some fake work orders to the contractors and asked them to supply materials like cement, iron, rod, CIC, electric ceiling fan, and some other articles in the name of SP Lakhimpur, not Lakhimpur, and procured the same for your own personal use. That is the second paragraph. Then third, harder, you forged the signature of Superintendent of Police, Lakhimpur, Additional SP, North Lakhimpur, AIG, Assam, Guwahati, and others. And by using those signatures of the police officers, you pass some orders to sit the individuals. Then, thus, your above act have constituted gross criminal misconduct and dereliction of duty and rendered you fit to be retained in service, and you are therefore charged accordingly.
Yes.
This is sir. Then he was given 10 days time to submit his written statement of defense. Accordingly, he
Yes.
submitted, he denied the allegations.
Yes.
Then they are not satisfied with the written statement, the department, disciplinary authority appointed inquiry officer. Now, inquiry report is as page 45, 46, 47, 48, and 49. Inquiry report. 30.
Inquiry report has been given to you.
Lordship. And again, that I have also submitted my representation.
Yes.
And thereafter, not being satisfied, I have
Yes.
released. Now, Lordship, from the inquiry report itself, it appears that the inquiry officer examined as many as 7 witnesses
Yes.
on behalf of the department, including the 2 informants
Yes.
who lodged the FIR against me. And all remaining witnesses are police officers.
Yes.
Now, importantly, it is a list that I hold the signature of SP, Lakhimpur. Now, PW1, he is the SP. What he deposed before the inquiry officer. On examination, he stated that documents in question regarding placing of work orders and demanding materials from various firms by delinquent so and so of SP office were issued without his
Where are you reading?
page 46 Lordship. Deposition. 46 inquiry report. During inquiry,
40?
46.
Yes.
During inquiry, I have examined witnesses number 1, NMASF Hawk, APF CO, 3rd Battalion, Pitapur. Then
Yes.
2, Moinul Islam Mandal, CO, Katlichara. Then number 3, SI, Dilip Chandra Bora, 2nd officer. Then SI, UB, Babudhar Deuri, PSI, North Lakhimpur. Then 5, Lokesh Ghosh of North Lakhimpur PS.
This you have your witnesses,
No, it is
prosecution witnesses, who you have also cross-examined.
no, I never told it.
Opportunity was given.
Actually, opportunity.
Yes, it is shown here.
Now, what is the deposition of witnesses, Lordship? PW1. He has stated that the on examination, he stated that documents in question regarding fetching of work orders and demanding materials from various firms by delinquent Devananda Bora of SP office, Lakhimpur, were issued without his knowledge. And so made on these documents were not given by him. That is his saying. Now, it will be best known to Devananda Bora as to who has given this signature. On the basis of complaint received from civilians for sitting criminal cases were registered against Sri Devananda Bora in this connection. But those signatures, those documents are not exhibited, not even shown to the PW1. And regarding the statement evidence that against the petitioner, police have registered 2 criminal cases. Yes, but from both cases, I was acquitted. And because prosecution has failed to establish charges against me. Then, let's say PW2 is additional SP, Biden. On examination, he stated that the signatures put on letter number so and so, dated so and memo number so regarding supply order to MS Ghosh contractor are not given by him. And these letters were issued without his knowledge. On the basis of complaint received from civilians for sitting criminal cases were registered against so and so. Now, this Ghosh contractor was also not examined, and the document alleged to have been forged or signed by the petitioner also not executed. Then PW3 is a police officer, 2nd officer, Lakhimpur police station. What is evidence is there? on examination, he stated that on 23rd/12/2003, he was second officer, North Lakhimpur Police Station. And on that day, he was in charge of the officer in charge. He received FIR from Dilip Gogoi, Peon, DTO office, and on receipt of FIR, he registered the criminal case under section 406, 402, 420 against the petitioners who took rupees 35,000 from Dilip Gogoi, giving assurance to give a job to his son, Devadi Gogoi, but did not return the cash money. And later on, he seated him and misappropriated. That is his evidence. He entered the case to SI Babudhar Deuri. Babudhar Deuri is the IO. NLPS to investigate the case. Again, on 28/12/2003, on receipt of FIR from Novokumar Phokon, second informant of Lakhimpur Town, so-and-so, case number 989/2003 under section 406, 420 IPC against Devananda, who took loan of rupees 3,37,000 from the complainant Novokumar Phokon, giving assurance to return him. He borrowed the money and assured to return within 7 days, but did not return the money within stipulated time, and thereby he cheated. On the basis of agreement, he borrowed the amount. This is his evidence. Then court, Babudhar Devi, SI. On examination, he stated that on 23/12/2003, he was PSI NLPS, and on same day, on receipt of FIR from Dilip Gogoi, Peon, DTO office, North Lakhimpur, against Sri Devananda, who took
Mr. Counsel, I've read your the evidences. Sorry, I'm a little fast.
No.
But okay, the first few witnesses may not be very essential because these SIs have only deposed to the fact that these allegations have been received, FIRs have been received, and they have registered. And
Sure.
they have not, they have also been transferred. They don't know what is the fate of those FIRs.
No.
But PW6, Dilip Gogoi, and PW7, Novokumar
Yes,
Phokon.
They are the informant.
Yes, they have stated. Now, this is not a criminal proceeding where the standard of proof is beyond reasonable doubt. Here it is to probabilize. These witnesses have clearly stated the first number PW6 that yes, you had taken the money with the assurance of giving him a job, and PW7 that you have come and given that work order. So these are they have probabilized. And you have not shaken it. And anyway, this court is, as I have said, this court has a very limited jurisdiction in such matters. This court cannot go into all these realm. So,
Lordship may kindly see. Page
see,
96.
if PW 6 and 7 was not there,
That is-
I was thinking perhaps it's absolutely perverse. But then 6 and 7 are there.
Yeah, Lordship. Page 96 may kindly be seen.
Page
96. That is the judgment of the trial court.
of the trial court, the
Yeah.
criminal court,
Criminal court, Lordship.
acquitted.
Acquitted
That's all right.
on merit, Lordship.
That's all right.
That is my point.
No, acquittal would not automatically discharge you in the disciplinary proceedings as well.
There are two lines. One is when a case, criminal case, involves both criminal as well as misconduct. In that event, the department can proceed this by its own. Criminal cases will proceed differently. But when there is no misconduct in the allegation, department has no authorities.
I have all right. Then I have noted this submission of yours
What?
that according to you, there was no misconduct
Yes,
in the
it is-
allegation. Therefore, the initiation of the inquiry is bad.
Hmm.
Correct.
Lordship,
I shall deal with that submission of yours.
I will submit
Yeah.
a judgment. Yes, Lordship. Dilip Gogoi has stated that, what he stated in his evidence that his son, Devojit Gogoi, passed the interview of job held by 13th APBM in the year 2000. And in order to bear the expenses of job, he sent the accused, that is petitioner, to give, along with a sum of rupees 35,000, to give it to a man at Guwahati. That is his evidence before the competent criminal court. Okay? So both are contradictory. What he stated before the departmental authority and herein are not same. This is my point. So, but later on, the man, that means in Guwahati, could not help him in getting the job by PW2, and so he lost the instant case. That is it. Not getting the job, he lost the FIR. Now, my Lordship, to this extent that whether department can proceed purely on criminal matters, which only competent criminal court has jurisdiction, department can proceed during pendency of that criminal trial. To this extent, I'll submit a judgment delivered by Jharkhand High Court Division.
Yes, yes.
Lordship. Now, Lordship, what are I mean, APF is in opposition of the department. So to make kindly very short, I'll just sort out. So far, registration of 2 cases are under section 406 and 420 are concerned. It is no doubt we are also admitting. Now, there other plea is there. Okay. IO has arrested the petitioner and production in the court of learned CJM, that is para number 6, their affidavit, involved in issuing fake orders to some supplier with 4 signature of SP, AIV, etc. CTEX. Whether arrest and detention in connection with a criminal case amounts to a misconduct or dereliction of victim. That is another my point. Then they have, then in another paragraph 9, they have stated that that show cause notice was issued to the petitioner as per prescribed rules. The offences committed by the petitioner was gross misconduct while discharging his duties. Now, to this extent, while charges are served upon the delinquent, it must be definite. That is prescribed in the rule. But their contention is that the petitioner has committed gross criminal misconduct. Now, while say in PC Act cases, yes, in PC Act cases, both police can proceed, also department. But this is not the case because the entire BP is founded on 2 FIRs. And as per FIR and even the statement of allegations, the department lacks its jurisdiction because there is no misconduct as well offense. Maybe offense, but not misconduct. It is my symptom.
All right,
Then-
noted.
Lordship, then violation of Rule 9, Lordship.
What is
Violation of
rule 9?
Rule 9, yes. And as per Rule 9(2), the disciplinary authority shall frame definite charges on the basis of allegations on which inquiry is proposed to be held. But herein, no such definite charge is framed, so it amounts to violation of Rule 9(2). Now, Lordship,
Put the solely at 20. Fine.
then
Lordship to the common or any. Is it a common or
Yes, sir.
Well, Lordship, inquiry report. Page 49 make an division, Lordship. 49.
Yes.
After discussion of the statement of all PWs and as well as the statement of delinquent, and after going through the relevant documents, it came to light that delinquent Devanando Bora, stenographer, so and so, had issued some work orders, supply orders to some persons by taking illegal advantage of his official capacity as stenographer of SP Office Lakhimpur without the knowledge of SP Lakhimpur, additional SP, so and so. Moreover, the delinquent took some personal loan from some of PWs, giving assurance to repay the amount within stipulated time. But he did not repay the same amount except he paid rupees 3,000 to Dilip Gogoi and thereby seated. That is the sum and substance of the inquiry report. Now, under Rule 9, Sub-Rule 7.
Rule 9 Khandya.
How inquiry?
1 second, let me have the rule. Yes. এখন নহয় নেকি? Yes, rule 9, how does it read?
7. Sub-Rule 7.
No, এখন নহয়। Rule 10. This is rule 9.
Okay. Rule 9, Sub-Rule 8 contains how inquiry report is to be prepared.
Sub-rule 7.
8, 7 and 8. 7,
Yes.
the conclusion of inquiry, authority shall prepare report.
Yes.
Report is to be prepared, recording its finding on each subject. On
Yes.
each subject. But it is lacking in the inquiry report. 2 subjects. There is no reasoning how the charges are proved or not proved. Violation of Rule 9(7).
9(7) or 9(8)?
9, both 9(7), 9(8), because 9(8) contains how report is to be prepared.
Okay.
First, charges to be definite. Then secondly, written statement is to be reflected. Oral evidence taken in course of inquiry. Then documentary evidence taken in course of inquiry. Then 5, order, if any, made by disciplinary authority and the inquiring authority in regard to the inquiry. And 6, a report setting out, that is important, a report setting out the findings on each charges, finding on each charges. But herein it is totally lacking, Lordship.
Okay.
And the reasons gap. There is no such reason.
Okay.
Then the 9(9), the disciplinary authority shall, if it is not the inquiring authority, herein the disciplinary authority is different, inquiring authority is different. The inquiring authority consider the record of the inquiry and the record its own finding on each charge. Again, they are to give their reasons on each charge.
Yes, where is that disciplinary authorities order?
Rule 9.
No, where here?
Yeah.
In the petition.
Yes, yeah. Yes, Lordship. Paragraph number 17, page is also 17 in the petition.
No, where is the order of the disciplinary
Oh, okay.
authorities accepting?
Lordship,
Where is that order?
Lordship.
Rule I've understood.
Annexure A, page 57.
Yes.
Order. Peruse the findings submitted by the inquiry officer. So, in connection with departmental proceeding drawn up against stenographer so and so of the office of so and so, North Lakhimpur. I have also gone through the entire record containing in the departmental proceeding file. The inquiry officer could prove the charges leveled against the delinquent beyond reasonable doubt during the course of inquiry. This is the only conclusion. I hope that charges are proved, no independent conclusion proved, and agree with the finding of the inquiry officer. Due opportunity was given to the delinquent during the course of inquiry to present his case and defend himself. Copy of the inquiry report was also made available to so and so. Second show cause notice was also issued to the delinquent, and he submitted the reply of the same, which was found to be unsatisfactory. I therefore, upon being satisfied with the merit of the case, decide to award the punishment of removal from service to so and so, so and so. So and so will be entitled to career pay and allowance other than what he had already done for a period so and so. This is the finding of it. There is no independent conclusion on each charge.
All right.
Lordship, in this connection, we have our judgment from our own high court and submitting, Lordship. And regarding one, that the allegations does not contain both misconduct as well as
Copies book judgment or and one Jharkhand also you said some
Jharkhand.
give all the judgments you want to rely. Yeah. First one is on definite charge, all right. Paragraph 7, 8, 10, 12. Yes, read. Yes, Mr. Counsel, read para 7 of the first judgment.
First judgment, okay. Devobrov C and others.
Para 7, read para 7.
Para 7. A perusal of Rule 9 make it clear that no penalties is specified in Rule 7 of the Rule of 1964 are to be passed except in consonance with an inquiry held in the manner prescribed therein. So inquiry must be in consonance with the rules prescribed therein.
You read.
Yeah. Definite charges are to be framed, which is to be made over to the delinquent along with the statement of allegations and affording opportunity to file written statement of defense. What is of utmost importance is that at the time of delivering the charges, the government servant facing an inquiry must invariably furnish with the list of documents and witnesses by which each article of charges is proposed to be sustained. Additional safeguard is also provided to the government servant in that for the purpose of his defense, he must be permitted to inspect and take extract from such official records unless the disciplinary authority is of opinion that the same are not relevant for the purpose or it is against public interest to allow such access to the government servant. The inquiry advises consideration of documentary evidence and taking oral evidence by the inquiring authority as may be relevant or material in respect of the charges. Opportunity to cross-examine witnesses, examine in support of the charges, as well as to give evidence in person and to adduce documentary and oral evidence in his defense are built-in procedural safeguard and vices under Rule 9 of Rule 64. Exception is made that if the inquiry authority declines to examine any witness or to admit any document in evidence on ground that such evidence or document is not relevant or material, reasons in writing will have to be recorded. An inquiry stands concluded by preparation of an inquiry report, recording the finding on each charge together with reasons therefore. Rule 9 further contemplates that the record of inquiry almost other is to include the oral evidence taken and documentary evidence considered in the course of inquiry. Obligation is also cast upon the disciplinary authority, if it is not the inquiring authority, to consider the record of the inquiry and to record its finding on its charges. This is the paragraph 7.
Yes.
Then in para 8, the scope and ambit.
I have read, Parai. Yes.
Then in Jharkhand case, Lordship, herein the petitioner was a police constable and a FIR was lodged against him for commission of offense punishable under section 376 IPC. Thereafter, department initiated the proceeding due to penalty of the criminal trial. Then what happened? The proceeding ended and he was dismissed from service. Then he preferred a writ petition before Honorable Single Judge of Jharkhand High Court. That was dismissed. Then he preferred appeal before the Honorable Division Bench. And Division Bench what recorded is there, paragraph number 4, Lordship.
Page?
There are page 7,
Yes.
paragraph number 4. We have heard the learned counsel for the parties and peruse the order impugned in the writ petition. We fail to understand how allegations as contained in the memo of charge can constitute a misconduct under service jurisprudence. 3 charges against the appellant relate to all: number 1, registration of a criminal FIR against him, then allegation as contained in the FIR charge sheet, then
As far as this point is concerned, Mr. Counsel, I am with you as far as Rule 9 is concerned.
No.
But as far as this is concerned, you see, yes, of course, if here the allegation was of rape or something else, then it would have been a different aspect. but there are also allegations that you have taken money in the assurance that a job can be assured.
Yeah.
Now, you see, whether that allegation is correct, not correct is a different issue.
Lordship,
But to say that that allegation cannot come under the misconduct is a little too much in the end of the day, right? Because you are working as a stenographer in the office of the SP, the recruitment process for the constable. You are taking money on the name that you will assure that he will to secure him the job for which he is giving the interview. That you cannot say, "Okay, no, this is nothing. It has no connection. It cannot be the outside the scope of the inquiry officer or the disciplinary authorities." How can you say that? Because he is working as a steno in the office of the SP concerned. Anyway, that so
we have annexed
there is no quarrel as regards the proposition laid down in the Jharkhand High Court. That is all right. But here, what was the registration of the case? The charges per se does not constitute misconduct insofar as the allegation is of rape
No.
and murder are concerned.
No.
Yes.
Okay, so for this job.
Yes. Next. Yes.
Then then yeah. Then we are submitting also Supreme Court judgment.
Yes. AL Kalra.
Lordship,
Misconduct.
misconduct.
Yes.
Okay.
This is only of loan, that is all right. But here, the difficulty is because assurance of the job. That is only where I'm having a difficulty.
Lordship, that is why.
If it was a simple loan, it's a different aspect.
Lordship, that is why I have annexed the judgment of the planet type. Herein
Very
he has
well.
given
We will
other
see that.
statement.
We'll see that.
Page 96.
Hmm.
Yeah, he has given other. He has not implicated me.
Show me that part in the trial criminal court's judgment once again. That particular page.
96, Lordship.
96.
96.
Yes, paragraph. There is no evidence.
First paragraph. Lordship.
Yes.
He sent the accused to give along with some of rupees 35,000 to give it to a man at Guwahati. Just to carry. But later on, the man in Guwahati could not help him in getting the job. So he has contradicted his own statement.
And that earlier round of statement is in which page?
During inquiry report.
Dilip Gogoi.
Page number 47, Code 7, Dilip Gogoi.
Okay, yes, next.
Then another judgment from High Court, it is page 32, 3, 4, 5. Pulok Chandra Bora, but State of Assam, okay? The same judgment, 2023. Page 8, 9, 10, 12, 14, and 18.
Yes.
In here, paragraph number 8. I think it is law is now well settled that departmental inquiry and the punishment thereof can be interfered in exercise of judicial review only when the order passed of proceeding was contrary to law or relevant factors were not considered or irrelevant factors were considered on the decision, or the decision was one which no reasonable person would have taken, or in violation of the principle of nature and justice, or the procedure prescribed is not followed. It is paragraph 8. Then 9. In the case in hand, it is an admitted position that the provision of Assam Services Discipline and Appeal Rules 1964 is applicable here in our case. So therefore, the respondent board can punish its employees only by following procedure as laid down in Assam Services Discipline and Appeal Rules 1964. Then Reason admitted position that no formal inquiry as contemplated under Rule 9, Sub-Rule 6 of the Assam Services Discipline and Appeal Rules 1964 was conducted. No presenting officer was appointed. Herein also, no defense assistance was allowed, but no witnesses were examined or allowed or cross-examined, and two-man committee concluded to this section. Also. So from all this logic, the imperial order, even inquiry, is not in accordance with rules prescribed by the Assam Services Discipline and Appeal Rules. Order, settled law is.
All right, noted.
So herein I want to say one. The petitioner has reached the age of superannuation. So I don't know the fate of my case. In that case, he cannot be reinstated in service.
Anyway, let us first hear the other side.
That is why I have cleared it.
All right.
So my submission is there. The proceeding, punishment, everything request.
All right, noted.
Lordship, can I make my submission after going through the judgments? After going through the judgments that he has had?
Raji,
No, Lordship, today itself, Lordship.
what
I'll
were you
just take-
doing all this while we were reading? He was taking us through these paragraphs.
He is reading, but they have not provided it to us. So I just want to.
You have your mobile, you have your apps, you could have just had
Yes,
it.
Lordship, that's.
Not
But-
that difficult. Anyway, we'll go to those decisions if required. Your response is required in these decisions. First of all,
Okay.
you clarify the court's queries.
Lordship,
Yes, Mr. Counsel, you take your seat now.
Lordship.
Rule 9. Mr. Chaudhary, Mr. Daz, is it freezing this side or is it also freezing the other side? Huh? I think, I don't know. I've asked him to reduce it, but it seems there is no control. Huh? Already off-code If you feel hot, please tell them. I think for some time we can turn it off. Otherwise, we'll all catch cold by the end of the day. Yes. Yes, Ms. Bhattacharya. Now, please tell me one thing. Reading of rules 7, 8, and 10. This too you have?
I'm having lordship.
Yes. Now, one thing which appears is that both the inquiry officer as well as the disciplinary authority
Lordship.
must record reasons of each charges, right? At the conclusion of the inquiry authority, if he himself holds will prepare a report of the inquiry, recording its finding in respect of each of the charges and furnish reasons therefore. All right? Then 10, the disciplinary authority will consider the record of the inquiry and record its findings on each charges if the inquiry is not held by the disciplinary authority. Now come to your inquiry report. See, these all are there till page 46. Only the evidence, right?
Yes, Lordship.
PW4, then page 47, PW5, PW6,
Lordship.
page 48, PW7, then the statement of the delinquent.
Delinquent.
Now you come to 49.
Lordship.
Now read that.
After discussion of the statements of all the PWs and as well as the statements of delinquent, and after going through the relevant documents, it came to light that the delinquent Sri Devananda Bara, stenographer of SP office North Lakhimpur, had issued some work orders, supply orders to some persons by taking illegal advantage of his official capacity as stenographer of SP North Lakhimpur without the knowledge of SP North Lakhimpur and additional SP North Lakhimpur. Moreover, the delinquent took some personal loans from some of the PWs, giving assurance to repay the amounts within the stipulated time. But he did not repay the same amounts except he repaid rupees 3,000 to Dilip Gogoi and thereby he cheated them. Without prejudice to the cases registered against him at Lakhimpur PS case number so-and-so, so-and-so. Therefore, the charges of misconduct as well as the dereliction of duty brought against Sri Devananda Bara stenographer is well established beyond all reasonable doubts.
It doesn't appear to be completely applying its mind to the charges. What was the charges? Where is the charge of taking bribe and all? PW6. Read PW6.
Yes, Lordship.
What happened to PW6?
Dilip Gogoi. On examination, he stated that he was a peon of DTO office, North Lakhimpur. In the year, he was staying in a rented house at Anandanagar, North Lakhimpur town, and once Sri Devananda Bara, an employee of SP office, North Lakhimpur, was staying in the same compound in a rented house. The said Sri Devananda Bara met him at his rented house and gave a proposal to him that if he paid rupees 35,000, he will be able to give an employment in Assam Police Battalion to his son, Debojit Gogoi, who appeared in an interview for the post of AP Battalion Constable held at 13th AP Battalion Lilabari in the year 2000. Accordingly, getting assurance from Sri Devananda Bara on good faith, he paid rupees 15,000 on 7/4/2003 and again he paid rupees 20,000 on 4/7/2003 to Sri Devananda Bara without receipt. After taking rupees 35,000, the said Sri Devananda Bara untraced from the rented house for long period, and one day he met the Deputy SP headquarters, North Lakhimpur at DTO office, North Lakhimpur, and he reported the matter to Deputy SP headquarters.
So, Ms. Bhattacharya, this is not there in that finding, number one.
Lordship.
Now, if we go by strictly by page 49, that finding,
Lordship.
if suppose he has taken loan and he's not paid, that is a case of cheating. How can you do misconduct for that?
Lordship.
This should have been discussed, no? This PW6 is there. Now you come to the disciplinary authority. What does the disciplinary authority do? Page 57, I think.
55, Lordship. Okay. There is the finding submitted by the
Yes,
inquiry
57,
officer.
yes. Read.
Inquiry Officer Sri Aftab Laskar, APS Assistant Commandant 13th AP Battalion, Lilabari, in connection with the departmental proceeding drawn up against stenographer Debananda Bara in the office of the Superintendent of Police, Lakhimpur, North Lakhimpur. I have also gone through the entire records containing the departmental proceeding file. The inquiry officer could prove the charges leveled against the delinquent beyond reasonable doubt during the course of inquiry. I hold that the charges are proved and agree with the findings of the inquiry officer. The opportunity was given to the delinquent during the course of inquiry to present his case and defend himself. Copy of the inquiry report was also made available to Sri Debananda Bara. Second show cause notice was also issued to the delinquent and he submitted the reply of the same, which was found to be unsatisfactory. I therefore, upon being satisfied with the merit of the case, decide to award the punishment of removal from service to.
So where has he recorded its findings on each charges? Where is that? Where is his independent exercise of mind? He simply says he's read it and he agrees with the findings. Where are his reasoning? He's not a postmaster.
Lordship there, sir.
Where is his independent exercise of mind? Sub rule 10 of rule 9.
Nine.
This is, I'm indicating this because this is what
Yes, Lordship.
you have to now answer. Huh? Where is the independent exercise of mind? It doesn't appear.
Lordship.
And the inquiry also officer also
Lordship.
cheating. If it's a case of cheating, then that is for the
It was-
criminal court.
Because this was
Isn't it?
only, yes, Lordship, misconduct and dereliction of duty. This was the charge.
Correct.
that
But
was-
if
yes.
the delinquent is
Understood.
taking money from some private
Yes.
person, can your office now say that this is misconduct if because he's not being able to return, even assuming that is correct? How is it affecting the how unbecoming of a stenographer of that office? I could have understood if on the evidence of PW6, the inquiry officer would have held him guilty of misconduct. That aspect seems to have been just forgotten. What happened to that?
And of another contractor who was also PW.
That I have seen, supply order.
Supply order.
That the supply orders are by him and he is not.
Then statement by Deputy SP
But
also.
where are
that-
these? Where is the independent exercise of mind of the disciplinary authority?
Lordship.
Now, now non-compliance of sub rule 10 of rule 9, whether that would be fatal to the entire, would it vitiate the entire inquiry proceeding?
Lordship, I just need to go through this again, Lordship, and I'll get.
Now, what do you need to go through? The coordinate bench judgment has already said that rule 9 is mandatory, relying on a 3-bench judgment of this court. Paragraph 7, paragraph 8, T.S. Srivastava, AIR 72, Guwahati 2. Rule 9 is mandatory. Thursday. Ms. Bhattacharya, Thursday I'm keeping it.
Today also, Lordship,
2
in the
o'clock.
second half, I had no problem, Lordship.
2 o'clock.
That's what
Get
I'm
hold
saying.
of this decision.
Yes, Lordship.
That the 72 AIR, huh? Get hold of that
Yes.
decision. If you want to make photocopies of the list of the case laws that has been
Lordship, I'll
given,
take.
just take it from the court to DDBO. And I think Mr. Chaudhary, Mr. Das, you all are ready. আবার মাতি দিয়া যে আছে কৰি মেডিয়েশন খিনি আমাৰ agreeable, Mr. Biswas?
No lordship,
Huh?
no lordship.
No, it is not agreeable. Huh? All right. Give your names, huh?
Yes.
Yes.
Item 4.
Agreeable, not agreeable. Agreeable, both parties. Agreeable. Give your names, huh? Then you will get the date of the mediation.
Item 6.
Agreeable.
Agreeable. Other side, Mr. Dhar. Agreeable.
Item 36.
To mediation. Or? 9. In item 36, none appears despite the matter being called twice today. Relist next week, huh?
Lordship matter already complied with.
Complied.
Yes.
So it can be closed.
Yes.
Item Tukiman?
37.
Give. Heard Mr. R. Kaman, right?
Yes.
Learned counsel appearing for the writ petitioner, also heard MS. So and so learned counsel appearing for the respondent. Stop. Mr. Kaman submits that during the pendency of the instant writ proceedings, comma, the issue involved in the writ petition has already been settled. He further submits that the matter accordingly has become infructuous. In view of the aforesaid endorsement made by the learned counsel, made by Mr. So-and-so, the writ petition stands dismissed on being infructuous.
38.
Hmm?
38.
None appears for the petitioner on call despite the matter being called twice. Relist after 2 weeks on a date to be fixed by the registry.
38. Supplementary. Time being item number 10 to 30.
Mr. Das, I think 38 is your matter. Why are you being so lost? Agreeable or not agreeable? Yes, where is that respondent counsel? Yes, why are you running away now? Agreeable, not agreeable? Not agreeable. Huh?
Not agreeable.
That is why you are running away.
No, actually brief is there, so.
Acha. NC Das, so for the petitioner, return to Didva, NC Das agreeable and so not agreeable. Therefore, not agreeable or formatted bonai. Copy to Didva.
Deep proof. Item 10 to 12.
Yes, what is this?
Lord, these are all.
There are total 4 matters.
Yes. Effectively, 2 matters.
Mr. Das also, I think, was there.
He's on decks in another course, but he'll come.
All right.
I'll start.
Yes.
Well, basically, we would like to invoke para 53 of Uma Devi without intervention of the court.
This are listed to item numbers as well. 10.
Beloved will kindly have WPC 938 of 2020.
10 to 13, na?
938 of 2020.
You want which petition to be taken up?
938 of.
Yes, I think I have 938. Yes. So that's the lead case?
Yes.
Yes.
Milord will kindly come to page 29.
Page
29, Milord.
Yes.
Now, this was the advertisement, Milord. Office of the Principal, Cotton College. At that point of time, it was Cotton College. Applications along with all necessary documents are invited from interested candidates for position of academic counselor ad hoc in the Department of Computer Science and IT Cotton College on or before 25th of February. So this was the advertisement, Milord. Then at page 30.
Post is of academic counselor.
Actually, these are all faculty members.
I don't know.
Yes.
Then, Milord, at page number 30, on 6/8/2007.
1 second.
Yes.
page number 30.
30 Miller. Petitioner number 1 is appointed.
Just, can we just read the appointment order?
Yes, Miller.
Hereby appointed
It
as
is
so
my
and so.
pleasure to inform you that you are hereby appointed as academic counselor in Cotton College, Computer and IT Education Center, Cotton College, Guwahati, for a period of 3 months with effect from 6/8/2007. You will be entitled to a remuneration of rupees 6,000 per month. You are requested to join your duties with immediate effect. Then, my lord, at page 31, this is the appointment order of petitioner number 2.
Yes.
Then petitioner number, page number 32,
So
appointment.
they are all appointed as
Appointed.
ad hoc, no?
Ad hoc,
Yes.
there is no difficulty on it. Similarly, at page 34 is the appointment order of
P3.
petitioner number 4.
Four.
4.
How many
5,
petitioners?
there are 5 in that, in fact. Biswajit Das.
No, this is Atwar ul. Page 32 is Atwar, no?
Atwarul Islam,
Will be
petitioner
3.
number 3 Miller.
3, that's what. And Nobonita is
Petitioner 33.
Page 33.
Yes.
Pitna 4.
3 Miller. Yes, petitioner of 4. I'm sorry.
Yes.
And page 34 is petitioner number 5.
Okay. Yes.
Page 35 Miller, extension order of petitioner number 1. It is my pleasure to inform you that your tenure as academic counselor in Computer Science and IT department has been extended for another period with effect from April 2011 to July 2011. You will be entitled to remuneration of 13,500 only, house rent at the rate of 15%, etc., etc. So this is how, my lord, the extension orders are there from page up to page 39. Then if your lordship would kindly come to page number 40, my lord.
Yes.
Now, with the approval of the Vice Chancellor, Anupam Das, petitioner number 1, was appointed as, my lord, Assistant Professor. Contractual. Page 40.
40, right?
Yes.
Yes. Yes.
Similarly, my lord,
He was appointed as
now
assistant professor.
Now this time
Contractual.
as assistant contract.
So from academic counselor,
Yes,
he is now made assistant
professor.
professor.
So from page 40 to 44, my lord, are orders
And the initial year that
2007.
2007. And this is 2020.
Yes.
Yes.
So this is how, my lord, they were continuing.
So they,
Now,
this is also contractual.
the contraction, there's
Yes.
difficulty, my lord, but they were continuously, they were serving without
Very
any
well.
break.
Very well.
Now, my lord, please come to page number 50.
Yes.
Now, this is a communication by President of the Cotton College Teachers Association to the Chancellor of Guwahati, Cotton College State University. By this time, my lord, the status of Cotton College became a state university. With due respect, we the undersigned would like to state the following lines for your kind consideration. Department of Computer Science and IT, established in 2004, has been showing excellent results not only in academics but also in placing its students in various reputed multinational companies during the last 5 years. Although the department has one regular assistant professor the services of 6 assistant professors who shoulder all the responsibility given by the college authority in spite of normal duties cannot be ignored. Therefore, it is necessary requirement to regularize the services of the assistant professor who have been rendering their service sincerely and dedicatedly for the smooth functioning of the department. So, my lord, there were only one regular incumbent, rest were all the petitioners who were managing the show. Therefore, my lord, the president of the Cotton College Teachers Association wrote to the chancellor that their case for regularization should be taken up with the government. Then, my lord, will kindly come to page 51. This is a communication by Office of the CMO, my lord, to the Commissioner and Secretary Higher Education. I am directed to enclose herewith a letter dated 15/12/12 received from Secretary Cotton College Teachers Association to the Honorable Chief Minister requesting to regularize the services of the assistant professor for favor of your kind information and appropriate necessary action. In the meantime, my lord, the petitioners also represented before the Education Minister, which your lordships will get at page number 52.
51 was the commissioner
Yes,
representation, no?
Then, my lord, at page 54,
Your basis, perhaps your claim is for the regularization,
yes,
right?
because
And
I'm-
it is from that document which you just showed,
yes,
where they said that the 6 officers should also be
yes,
regularized. From there it is.
yes. Then, my lord, will kindly see now at page 54.
So how many are there? Total 6.
No, no, my lord.
You are 5 petitioners.
No, I think গোটেইকেইটা আছে নে এতিয়া? এতিয়া আজি তাৰিখত ইয়াতে আৰু ইটো কেছত total 7 million.
Total 7. Out of the 7, 1 post is already there. No.
The vacancies are there, Miller. I'll
Yeah,
show the
yeah.
vacancy position little later, Miller. Now, if lordships kindly comes to page 54, this is a communication from the Deputy Secretary Government to the Principal. Because, my lord, the Teachers Association took up the matter, therefore, the CM Secretary directed the Commissioner, therefore, my lord, things were moving. Regarding regularization of services of Assistant Professor in the Department of Computer Science and Information Technology. With reference to the subject cited above, I am directed to enclose herewith a copy of the letter under reference, along with enclosures and requests to kindly to submit a formal proposal for regularization of service of the assistant professor. So the government in the higher education department is directing the Cotton College to send the formal proposal. Now the principal is writing, my lord, to the government at page 55. With reference to the subject cited above, I have the honor to inform you that a number of posting teaching position of Cotton College are lying vacant. The current vacancy in the teaching position is 43. In this connection, I would also like to inform you that a few subjects, namely sociology, psychology, mass communication, environmental science, have been introduced as elective subject with effect from the session 2016-17 with proper approval from Cotton College State University. In addition to these subjects, a number of skill-based diploma and certificate courses have also been running in the Cotton College, which have been approved by Cotton College Student Society. However, no regular teacher in sociology, psychology, mass communication, and environmental science are appointed in the college. If at least 1 or 2 teachers are appointed in this subject, these subjects may be taught as a core subject from the next academic session. Now, please come to the last portion, Miller. That's our Cotton College State University has also appointed a few teachers in the existing departments. Therefore, it is possible to transfer a few vacant posts to the proposed department and also to the existing Department of biotechnology and computer science and IT. The detailed statement of vacancy position is enclosed herewith for your kind necessary action. In the above, I would like to request the government to take necessary step to fill up the vacant post in teaching position and grant permission to start the above mentioned subject, that is so and so, so and so, so and so, as 4 subjects in the undergraduate level from the next academic session.
Mr. Chaudhary,
Yes.
this letter
Yes.
is in response to the 54, because 54 letter was to the principal, right?
Yes, Mila.
From the deputy secretary.
Yes.
Where the deputy secretary had asked the principal.
To send a formal proposal.
Correct, for regularization. So this is the.
Yes.
This 55 is his response.
Yes, Mila. Now, my lord will kindly come to page number 58.
Yes.
Now, the director higher education is writing to the registrar Cotton University. In the meantime, the status also changed. With reference to the government letter on the subject cited above, that is 16th of September 15, I would like to request you to submit a formal proposal in connection with regularization of services of assistant professor in the Department of Computer Science and Information Technology of a university for further necessary action of the government. So this time director is
they've
writing-
confined it to the same subjects.
Yes, computer science, Miller, and IT.
It's the same thing.
Same thing, same.
Same thing as that of 54.
Yes, yes,
Correct.
yes. Similar letter is addressed by government also, Joint Secretary at page 59. Then my lord will kindly come to page number 60.
Where is the similar letter? Page
59, Miller.
59. Okay.
Earlier it was director, now Joint Secretary.
Joint
Higher
Secretary
Education.
also.
Yes.
Okay.
Now the reply is at page 60. Now the registrar is writing to the government.
So Deputy Commissioner, Director, and Joint Secretary. Yes.
With reference to the subject cited above, in regards to letter dated so and so received from Director Higher Education, had placed and discussed the matter of regularization of assistant professor contractual of both Artswell Cotton College and Artswell Cotton State University of the department in 5th of meeting of the Executive Council on 17 November 2018. The resolution is enclosed here. Now this is, my lord, what triggered the present litigation. Page 62, my lord. Instead of, my lord, keeping the request made by the state government, this is the resolution with Executive Council of the Cotton University too. Page 62 towards the bottom, my lord. Last one.
Maybe you can place this after the.
Yes, yes.
Huh?
Yes.
62. The suspense will remain.
My lord, at 2 o'clock, there is one matter fixed at in a particular. I will come little later, my lord. I think there are 2-3 other matters are also fixed.
Yes, then that M. Bhattacharya's matter is
Yes,
fixed.
yes.
So
After that, I'll do.
page. You remind me the page. Page 60.
I'll do that.
अच्छा नहीं जा रहे हैं
Lordship, I have gone through the records and all this, Lordship. And admittedly, Lordship, some lapses on the part of the respondents. So I just want to place one judgment of the Supreme Court, Lordship. And the
I was thinking of
matter can be
taking
disposed
the
of
clock
this line.
back to the discipline
Lordship,
from
on
to that stage.
Yes,
That's what I was also
Yes,
thinking.
Lordship. On the similar line, Lordship, this was also an appeal preferred by the respondents.
But where is that lawyer counsel for the petitioner? Where is he gone? Huh? How come he's not here? We fixed it at 2 only.
Yes, Lordship. Lordship already indicated. Almost similar, Lordship, procedural impropriety. So on 9, 10, and 11, Lordship.
But he's not there.
Lordship.
We'll have it on another date. What to do?
In another occasion also this happened, Lordship.
Oh, that's very unfortunate. I was almost sure that at
Yes,
least we could have discussed.
That's why, Lordship, I did not take that.
Correct.
because,
You have also assisted accordingly and is ready with the judgment. Right, like this.
Actually, I could have, Lordship. There's some internet problem. That's why I don't get this immediately, Lordship.
No problem. What is the name of that council? Mr. A. Sahad, his name is. Janani Namtu. Where is he gone?
Yes, Sahad, Lordship.
A or
Sahad.
S? A, I
A
think.
Sahad.
We write it down like this. Heard Mr. A. Sahad, learned counsel for the petitioner. Also heard MSM Bhattacharjee, learned additional senior government advocate for the state respondent. Be it pertinent that Mr. A. Sahad, learned counsel for the petitioner, concluded his argument however, MSM Bhattacharjee couldn't conclude her argument before the break, and accordingly, lunch break, and accordingly, the matter was posted at 2 after a break for resuming the hearing. However, at 2, Mr. A. Sahad is not present in the court. However, MS so-and-so completed her argument. In view of Mr. So-and-so not being present in the court, the matter is now posted to Thursday so-and-so. Yeah, আগতে তেওঁ দিছিলে নহয় কিবা কিবি সেইখিনি ক'ত ফুলা হয় এইটো This is 7th. ৰূপক এইটো মনত থবা এইটো by slip.
Timing item number 10 to 13.
Yes, Mr. Kashyap. Mr. Chaudhary is
Lordship, he is before court number 14. He'll be here in a few minutes, Your Lordship. If Your Lordship would kindly.
Mr. Das. All right.
Fine.
Aru ase too.
Much.
Timing item number 23.
Yeah, please, Your Lordship. Lordship may take part into pensionary benefits and other consequential relief, Your Lordship, of a missing persons who is a state government employee, Your Lordship, who has been missing since last 7 years, more than 7 years, Your Lordship. This is the case, Your Lordship. In my case, governed by 143, Rule 143 of Assam Service Pension Annual, Your Lordship.
It is pension of the missing person.
Missing person, Your Lordship, and the rule covered in this case, Your Lordship, 143A, Your Lordship.
Rule
Assam-
143A.
A. Assam Service Pension Rules.
এখন দিব দেই। And this person has been missing since when? Huh?
Well, more than 7 years, Your Lordship.
Then-
More than 7 years.
Now,
Your
who
Lordship.
has applied? Wife?
Yes, wife and the son. Matter was fixed for Assam Service Pension.
Hmm?
Matter was fixed for instruction, Your Lordship, on their part, Your Lordship.
Yes, what instruction?
Irrigation department will make.
Whose irrigation?
Not end of part, Your Lordship.
Where is he?
In the break time, I saw him in the bar.
The son. The son.
So it's not that he is not being able to come because of waterlogging. He is in court.
He was there.
She.
See. See.
Get hold of.
Lordship, Lordship.
Because if if the instruction is there, we could have disposed of this matter. What does this rule say?
The whole procedure has been there, Your Lordship.
136, 143.
143A.
Mr. Borwa, can you ask somebody from your government, any junior? Huh? So the formalities are 1, 2, 3, 4, 5, 6, 7. Right, Ms. Barwa?
Yeah. What?
These are the formalities. Read them. Read it from the rule. What are the requirements before giving this benefit to the family members of the missing person?
Your Lordship, subsection 1, Your Lordship.
Yes.
When an employee disappears leaving his family, the family may be paid in the first instance the amount of salary due, leave encashment due, and the amount of ZPF having regard to the nomination made by the employee. After a lapse of a period, 1 year is provided under Subrule 5 below. Other benefits like death cum retirement gratuity, family pension may also be granted to the family subject to the fulfillment of conditions prescribed in the following subrules. The above benefits may be sanctioned by the head office after observing the following formalities. The family of disappeared employee must lodge a report with the concerned police station and obtain a report that the employee has not been traced after all efforts had been made. An indemnity borne as per Annex 1 shall be taken from the nominees or dependents of the.
So here that FIR is there
There,
and the report, where is the
report
report?
is also there.
Page.
Your Lordship.
First, give me
First
the FIR.
22, Your Lordship. It was an application, Your Lordship, normal application, and after that, we obtained that report, Your Lordship.
Yes.
Annex 3,
is the vernacular portion, Your Lordship. And
Yes.
again, one more, the report is there, that 23, Your Lordship.
Page 23, annexure
23, Your
4,
Lordship,
isn't
the
it?
vernacular portion.
Yes, read. This is not vernacular. This is English.
Oh, English, Lordship. This is
It's
the
handwritten.
handwritten,
You
Lordship.
you meant to say it was.
This was not handwritten.
It
Your
was
Lordship.
handwritten.
Handwritten.
Yes.
This is the police report that on 25/9/20, Sri Ajay Ganju, son of Pradeep Ganju, village Hatimura, PA Zaklamanda district, Nagaon, Assam, reported this police station to the effect that on 5/9/2017, one police report issued by the PS that on 2/9/17, Srimati Rina Ganju, wife of Sri Pradeep Ganju, alias Satlal, village Hatimura, PA Zaklamanda district, Nagaon, Assam, is reported this PS to the effect that her husband missing on 29 April 13. In this regard, an entry made at
Slow, Miss Barwa. Why are you so
in this
going
regard,
so
an
fast?
entry made at Jakhalabandha PS by GDE number 815 dated 30 April 13 and also WT sent to all OCs of Assam. Inquiry has been made but not found the missing person and reply of WT not found till date. This reference Jakhalabandha PS ZDE number 28 dated 2917 and said police report to had lost due to flood of Zakhalabandha in 2017 and till date he is further not found. This reference Jakhalabandha PS by GD number.
So what does it say, Mr. Barwa?
What I say, Lordship, basic case of missing, there is a presumption that when a person is not known for more than 7 years, he is presumed to be dead. Now there is an order of the civil court. The order is at page number 39. The last paragraph, Lordship, when the defendant is said ex parte, page number 39 of the repetition. The court should consider the pleadings, evidence adduced by the plaintiff, and render finding as to whether prima facie case has been made out to decree the suit in favor of the plaintiff in the instead suit. The plaintiff have not been able to prove their claim by giving cogent evidence. After an analysis of the evidence laid upon, I hold my opinion in negative for declaration of civil death of Pradeep Ganjul, son of so-and-so, of Jakhalabandha Nagar, and direction to defendant number 1 for issuance of death certificate to this effect. Defendant number 1 is Health Department, Lordship. Now, Health Department certificate, whether it has been attached in the writ petition,
So there is a direction for issuance of death certificate.
yes, that
Here,
health certificate.
my submission to the effect, Your Lordship. Here, Your Lordship, I'm not on that point, Your Lordship, for obtaining death certificate on a missing person. My case is on the footing of only.
That is right, Mr. Barwa, because you
53A,
see,
Your Lordship, because the rule-
going by rule 143A, it says procedure for family pension in case of disappearance of government servant. So here you don't need a death certificate, right? What you need here is given under sub rule 3.1. That is that the family of the disappeared employee must lodge a report with the concerned police station, number 1. So number 2, and obtain a report that the employee has not been traced after all efforts had been made. Second requirement is the indemnity fund. These are formalities. But now that is why I'm asking you, Mr. Barwa, if the second requirement, yes, they have reported. That is there. Report they have given. Now whether the page 23 document.
Police report.
Yes.
Yes.
It is satisfying that point that all efforts, despite all efforts, not known. Because the last part, if you come in this regard, can you read that?
Yes, Lordship. Her husband missing on 2013.
No, just read in this regard.
In this regard, an entry made at Jakhalabandha police station of height so-and-so of 34 2013, and on also WT sent to all the OCs, officer in charge of Assam.
Full stop. Okay.
Yeah.
Then
Enquiry has been made but not found the missing person, and reply of WT not found till date.
so inquiry has been made but not found the missing person. So that is there. Then you see this reference.
This reference, Jakhalabandha PS white so-and-so GDE 624 dated 2020 as per previous record. So this basically satisfies the requirements of.
Correct. Then So why can we not dispose of this writ petition?
Directing the.
Directing the respondent authorities to consider the prayer in terms of
Of the police report.
no, in terms of Rule 143A. So that will cover. Why should we specify about this police report? They know how it is to be considered, right?
Now, whether this police report has been placed before the department.
See, it is up to them now. If we are not directing anything, we are only directing the respondents that to consider the representation if filed
42, page number.
under 143A.
We have filed, Your Lordship.
All right. So where is that representation?
42, Your Lordship, page number.
42. So that's all. You are for irrigation.
Yes, Your Honor.
So we will just direct because it appears the 143A is there. So you see if the police report satisfies the condition and if all the conditions specified in sub rule 3 of that rule 143A, you act accordingly. Where is the representation?
42 page number in Act 11 series, Your Lordship.
Yes,
42.
42.
Page 42. Yes, please write down. Heard MSG Bora, Learned Counsel, appearing for the petitioner. Stop. Also heard Mr. CKS Barwana, Learned Bora, Barwa, Learned Government Counsel, as well as MS
Yes, no, Your Honor.
so and so, Learned Standing Counsel,
Yes,
Irrigation.
Respondent 1, 3, 4, 5.
Oh, in bracket 1, 3, 4, and 5. Our Government Counsel is for 6. By way of this instant petition under Article 226 of the Constitution of India, the petitioner is seeking release of pensionary benefits to the petitioners. Full stop. Inter alia. MS. No, sorry. It is the specific case of the petitioner. How many petitioners?
2 petitioners.
Petitioners.
Son.
That the husband within bracket what is the name of this person? That Birachu. है ना?
Birachu Ganju,
That
Kichua Ganju,
Birachu
and
Ganju.
Pichu Ganju. 3 names.
Father's name is late Biratsu Kondu.
Oh, sorry.
No,
Ganju.
I'm asking about the missing person's name.
Pradeep Ganju.
Pradeep
Lordship.
Ganju.
Pradeep
Missing
Ganju.
person is Pradeep.
Pradeep.
Lordship.
Okay. That one Pradeep Ganju, who is the husband of the petitioner number 1 and father of the petitioner number 2, while working as a helper under the head of respondent number 3 and 4, and subsequent was appointed as a helper under the head of the respondent number 3 and 4, and subsequently his services were regularized with effect from 22/7/2005 in pursuance of the government letter number so and so and finance department number so and so. Can you get in synopsis? My underline queries. It is the specific case of the petitioners that the said husband as well as father of the petitioners has been missing since 29/4/2013. Accordingly, a general diary entry bearing GDE number 815 on 30/4/2013 has been recorded, and afterwards a WT message to the officer in charge of police station concerned has also been sent for has also been sent. Full stop. It is the further specific case of the petitioner that despite the despite the police inquiring into the matter, the said husband stroke father of the petitioners could not be traced till date. Situated thus, the petitioner number 1 in the month of June 2013 filed an application before the respondent number 3 for granting pensionary as well as collateral benefits, but the petitioners were advised to obtain a death certificate of the missing employee. It is the further specific case of the petitioner that upon completion of 7 years since the said husband stroke father of the petitioners went missing, comma, the petitioners approached different authorities to obtain death certificate of the missing person. However, and finally, a declaratory suit was filed before the Learned Court of Munsim, Koliabor, Nagaon, Assam, wherein the trial court I think the trial court rejected, right?
Dismiss the
This,
on
dismiss the suit. It is the further case of the petitioner that despite that though the petitioner on 13/11/2023 has filed a representation before the respondent number 3 for grant of pension under Rule 143 capital A of the Assam Services within bracket Pension Rules 1969, hereinafter referred to as the set rules. Nothing has been done till date.
representation is there, Your Lordship, 13/11/2023.
Which was followed by another representation dated.
13/11/20.
Where is that?
42 page number.
No, I have 42. 42 is 13/11.
13/11/20.
And the first one is?
Was, Your Lordship, 29.
No, this is the 42 is the first only, I think.
No, it's the earlier one, Your Lordship.
It's 2013.
13.
That will not do. 2013 will not do. Situated thus, the present writ petition. MSG Barua, Bora, Learned Counsel for the petitioner submits that since under Rule 143 capital A, in the event that there is a procedure prescribed for family pension in case of disappearance of government servant, comma, the petitioners having submitted an application to the respondent for availing such benefit, comma, the respondent ought to have considered the representation filed by the petitioners. She further submits that since the police report indicates that the concerned police station has reported that the husband stroke father has not been traced after all efforts had been made, comma, the petitioners are entitled to receive the family pension of the disappeared husband stroke petitioner, father. Stop. You want to say something?
Actually, sister pointed out one thing, was the representatives on that page 42
does not contain any signature or any receipt.
Denied, your lordship.
Okay, I'll take care of that. Wait. Per contra, no, Mr. C.K.S. Barua and MS so-and-so fairly submits that since under section 143 capital A, there is a procedure for grant of family pension to the family members of a disappeared employee, comma, in the event representations are filed under the said provision of law, the same shall be considered by the authorities in accordance with law. Stop. That's it. That's your submissions. So in view of the, no, don't say that. Having heard the learned counsels for the parties and having noted and having taken note of Rule 143 capital A of the so-and-so rules, it appears that in the event a government servant who suddenly disappears, leaving his families and whose whereabouts are not known, comma, in the event the family members of such disappeared employee satisfies the preconditions contained under the provision of Rule 143 capital A, comma, the benefits of family pension and death cum retirement gratuity, etc., is given to the families of such government servant. Stop. Apt to refer to Rule 143 capital A, which read as under quote unquote Kodiba. Reading of the aforesaid rule, it further appears that in order that it is condition precedent that the family of disappeared employee must lodge a report with the concerned police station and obtain a report that the employee has not been traced after all efforts have been made. Amongst others, Kodiba. Stop. In the instant case, it appears that the family members has intimated. Where is that FIR?
Police
Page
23.
Has lodged, don't say lodged, huh? You have only given a GD entry information.
Information.
That information is not here.
Not in their lordship. They left there in the police station itself, your lordship. So I will able to annex it, your lordship.
Then don't say Kibili Kosa. In the case in hand, it is in the case in hand, it appears that the petitioner number 1 has reported to the jurisdictional police station as regards her husband being missing from 29/4/2013, and thereafter an inquiry was conducted. Stop. It further appears from the police report enclosed as Annexure 4 to the writ proceeding that the husband of the petitioner number 1 is not found till the report till the date till date till the date till the reported till the date of the report submission of the said report. Stop. Be that as it may, since there is a specific provision under the so and so rules to provide family pension to the family members of the disappeared employee, and a mechanism is prescribed as how to as to the conditions to be satisfied for availing such benefits, comma, I am of the considered view that this writ petition can be disposed of in the interest of justice by directing the respondent, more particularly
The head of the office actually.
respondent number
3.
respondent number
The
3
head of the office.
to consider the representation of the petitioners, if so filed, within 3 weeks from receipt of such representation, in accordance with the provision contained in Rule 143 capital A of the so and so, and pass necessary orders. Ordered accordingly, disposed of.
Your Lordship, a time limit may be specified, Your Lordship. Otherwise,
I think I've given a time limit.
Lordship, Lordship.
Disuna? Kiman dilu?
3 weeks.
Lordship.
3 weeks? I think you don't need more than that.
1 month and litigation.
All right, 1 month.
4 weeks.
One that fixed on 16th of October, my lord. It was came on 8th of
Wrongly listed. Mr. N.J. Khatonia, Learned Counsel, appearing for the petitioner, submits that this matter has been inadvertently.
In fact, in the order, it is mentioned as 16/9,
Yeah.
but on that day, my lord, it was fixed on 16/10 because I took time because they have filed the affidavit.
Up at the very moment when Mr. Chaudhary was about to reveal the suspense as what is the difficulty right now, what is the main issue, because he was taking the court through the recommendations for regularizations by the 3 authorities. And then we stopped. Correct, Mr.
Yes,
Chaudhary?
yes,
We
yes.
stopped there.
Yes, page 60, my lord. And precisely at page 62, my lord,
Yes.
as part of the resolution of the Executive Council, Council of the Cotton University, my lord.
Yes.
Please come to page number 62 towards the bottom. EC suggested that all contractual teachers appointed by erstwhile Cotton College and Cotton College State University across various disciplines of the university be encouraged to apply against the advertised regular post. The selection and recruitment of teachers would be in accordance with UGC regulation and Cotton University Act of 2017, and their experience may be given weightage as per the rule. My lord, in the ultimate analysis as it transpires, the Executive Council of the Cotton University, my lord, did not agree with the proposal or the move which was going ahead, my lord, regarding regularization. All that was decided by the Executive Council is that all these posts which are meant by, my lord, contractual teachers, those should be advertised and
They should apply.
yes, that is this is the decision taken, my lord. Pursuant to this, my lord,
Those orders which you had placed earlier,
yes,
those that commissioners, director, and joint secretary,
yes,
those were written to the principal.
No, my lord. Actually, what had happened, it was initiated by the Cotton College Teachers Association. Then actually, initially, my lord, it was moved before the Chief Minister's office. Then the Joint Secretary of the Chief Minister, my lord, wrote to all these authorities that there is a request, so it should be considered. So that is how thing moved, my lord. It did not ultimately crystallize into any, I mean.
This is the final
Yes.
resolution.
Eventually, my
This
lord,
is taken by the what is this called? Cotton College?
Executive Council.
Executive Council.
Yes, of the Cotton University. Well, lord, initially it was Cotton College, then
Yes,
it was
Cotton
Cotton
University.
College State University, and
Now
eventually Cotton University. It's a
University.
full-fledged university. Now, my lord, therefore, this advertisement was issued at page 63.
This is what you have challenged.
Yes.
This is
Four
of 2019.
Yes.
There is a stay.
Yeah, no. There initially there were some, sir, those were vacated, my lord. And my lord, the actual position is.
Mr. Das, you are for the Cotton University.
Yes. Now, my lord, subsequently, my lord, our services were also terminated at page 84.
Yes.
With regard to the subject and reference cited above, I am to inform you that you would not be required to continue as an assistant professor, contractual Department of Computer Science and IT, with effect from 10th of February 2020. You are requested to kindly hand over all official documents in your possession to the head of the department. This has been issued in accordance with the directive of the Guwahati High Court by order dated so and the approval of the Honorable Vice Chancellor. In between, my lord, there was other litigations also where for some time there was some interim protection. Eventually, those were also lifted. Now, eventually, my lord, the matter boils down to whether in the facts of this case, we can invoke the mandate or in Umadevi's case.
That right now you are not in service.
No,
You've been
not in
terminated.
service. Not in service. So eventually, my lord, now case, well, there's one judgment of.
What is the prayer? Let us see the prayer.
Yes. Here the prayer is, my lord, to interfere with the termination order and and the advertisement and to consider our case.
And in the other writ petition?
Yes, I'm coming. Here at the page 23, impugn termination order. Then, my lord, writ in the nature of should not be issued to render this so and so, regularize our services. These are the two prayers, my lord.
Advertisement also, isn't
Yes,
it?
advertisement also we have challenged. But in any case, my lord, pursuant to the advertisement, 4 incumbents have been appointed. Even after appointment of the incumbent also, my lord, there are vacancies.
How many posts were there in the advertisement?
My lord, regarding the vacancy position,
Does the
in the advertisement, 4 posts.
4 posts?
Yes.
And now, according to your
According to us, my
information,
lord, according to
one
us,
has been filled up.
yes, no.
Hmm?
According to us, my lord, there are total posts, 12 posts in the department. 12.
Okay.
Ah.
Out of which 14 was advertised.
4.
4 was advertised.
Yes.
And out of the 4, how many
No,
got
Lord,
filled?
when the advertisement was issued, already there were 3 incumbents in position. 4 were advertised. So 4 plus 3 makes 7. So there were still 5 to 6 vacancies were still there.
These figures appear somewhere in the
Yes,
proceedings.
yes.
Otherwise,
Yes.
just ask one of your junior to
No,
just
we'll do
give
that.
a
We'll do
precise note on all this.
Yes.
Uh,
Yes. Now, my lord, in this litigation, order to control.
And what are the challenges in the other writ? Who has filed the other writ?
Yes.
You are the petitioner?
Yes, I am the petitioner in Gautam Das's case also, my lord.
No, but there are.
Manoj Kumar Das, not Gautam Das, sorry. Now, if now Lordship will, for the present, if Lordship will kindly take WPC 5195 of 2020, my lord. So, no, sorry, I'm sorry.
519.
No. 1846 of 24.
That would be, I think,
1826 of 24, Manoj Kumar Das. 516
that is 12.
Yes.
12 is 285.
No, my lord. 1846 of 24.
Hmm?
Manoj Kumar Das.
Yes.
519.
There are two Manoj Kumar Das. One is Dr. Manoj Kumar Das, which is 5195, and one is Manoj Kumar Das, which is 385. 285, sorry. Correct.
Yes.
And who's this Anupam Das?
Anupam Das is the first petitioner in the matter which I moved.
938. Now, what is this
88.
9474? There is one more of Anupam Das. There is one more of Anupam Das.
I appear for 938 and 9474
Sorry, you appear
for 9474
9474 means?
WPC 9474.
No, just give, can you give me the item numbers?
Yes.
9474 is item number 11.
Yes.
Mr. Das, here you're appearing for the.
Cotton University.
Correct. Basically,
Both 938 and 9474 is both I'm appearing Cotton University. Other matters I am not appearing.
so you are in item 11
10
and
and 11.
10.
And my learned friend is appearing.
And Mr. Nair, you
All 10, 11.
He's
are all in the university.
He's for Cotton University. In these two cases,
Please, Mr. Nair, please give an appearance, please,
Yes.
for all the respondents and everyone. And I just want to know one thing because it's getting too clumsy in my head now. Because it appears that one petitioner has filed two petitions. So this the first petition, 938, is clear to me. What is the other petition?
5195 of.
No, 9474. Dr. Anupam Das, what is the second writ petition? Where Mr. Das is appearing also. Mr. Das, the second writ petition.
there was they sought for regulation of the case in the first case, 9474.
That is the first case.
And there was a
That is the first case.
Yeah, there was an advertisement for filling up the post. Advertisement filling up the
Okay.
post. That was put
So,
to challenge.
so that was the challenge in the first case, and subsequently, after being terminated, the second case.
The second
Alright.
case is that already they've been appointed.
All right. And I think the same pattern goes to the other person, right, Mr. Chaudhary?
Yes.
Manoj Kumar also.
Wait, 5 and subsequent.
So in Manoj Kumar, which is the first case?
938. 5195.
5195.
Anupam Das. Etu ki?
Kishore.
Okay. So
Yes.
first case, Mr. Chaudhary, the apprehension of advertisement,
Yes.
or already advertisement had come by then.
Yes.
What?
Now, in the second case, my lord, that I'm referring now, this is 5195 of 2020. Here, we have challenged. This is in respect of molecular biology and biotechnology. But this petition is filed by 2%, my lord.
Mr. Roy, you are also there in this case. That's why you are very leisurely
Yes.
roaming around.
He knows in any case nothing is going to happen to him.
No, but we are collecting the names, so you give yours.
Yes.
And in all the four cases.
No, I'm not.
So just ask your junior to give a proper appearance slip for your, otherwise name will not come.
Yes.
On the lighter note, Mr. Roy. Yes.
If the first two case, which my learned friend had addressed before the court, 938 Anupam Das, if he has finished up that, then I can give a reply. Then one by one.
No, I think the argument will not be very long. Look, let me.
Mr.
first
Das,
place the fact.
Mr. Das perhaps wants to go home soon.
No, I don't want.
Yes. Now, if your lordship would kindly take this 5195, my lord.
Yeah, 5195.
there was an advertisement, my lord, of 19/6/19, pursuant to which certain candidates were shortlisted. On 26/11/2020, it was at that stage, my lord, we moved this application.
This is not the same advertisement which you
No,
had shown.
no.
This advertisement is dated
19/6/2019.
19/6.
2019, my lord.
No, same advertisement.
Same advertisement.
So,
Same.
Page 38 is the advertisement.
yes, I have seen, you have shown me that is the same
Yes,
one.
yes. Department is, my lord, molecular biology and biotechnology. Yes.
Mr. Chaudhary,
Yes.
any very exceptional something you want to, because otherwise you see,
No,
I will get confused with,
No.
because
No,
ultimately I
that's
have to pass a
factual-
common judgment.
factual
If,
can done me.
that is why let us
Yes.
stick to the pleadings of one case,
Yes,
then
yes.
perhaps if it is all same, isn't it?
Yes, I'll stick to one.
Because if I have now understood that the first round you had challenged the advertisement.
Yes.
Since they completed the process, they terminated you, they appointed someone, therefore fresh cause of action, and you must have, correct?
Yes.
That is the main trajectory, I think.
Well, there is a judgment of the coordinate bench. What is the petition of petition that 24 or petition of put my name. Put your একটু নাই কিন্তু পুরোনো বস্তু একটু ফাইলটা বল দেখি একটু just give me 1 minute.
No problem, no problem.
এমাটো তোক লব দিছিল নাই মই এই যে 24 or petition এমাটো যে দিছিল Well, Lord, there is one judgment of a coordinate bench. That's very important in this case, my lord. I'll get a copy for your lordships. This is judgment dated 6/10/21, passed in WPC 5304 of 21. Ase on this. My lord, I'll invoke the judgment in this case, my lord. My lord will kindly come to first parameter, short facts.
Yes.
Asan Sharma learned so considering the nature of the order proposed to be passed, notice need not be issued to respondent 5 and 6. As by this order, we would require the Director of Higher Education to pass a reasoned order, and if director in this wisdom if deems appropriate may issue notice to respondent 5 and 6 if they are required to be heard in the matter. Petitioner is an MPhil by qualification and was appointed as a lecturer in the Department of English in Habraghat Mahavidyalaya in Gwalpara district on 27/2005 as per resolution of the governing body of the college dated so. The appointment order of the petitioner provides that it is on contractual basis, but the fact remains that petitioner is continuing to serve as such till date. It is also stated that the petitioner is working against a sanctioned vacant post in Habraghat Mahavidyalaya, but because of the initial nature of the appointment, which is stated to be a contractual appointment, petitioner had not been regularized in his service. Over the passage of time, the petitioner is disadvantaged to an extent that although at the time of initial appointment he had all the required qualification for the post of lecturer in English, but in the meantime, due to the subsequent changes in the required qualification, he may not be eligible for direct recruitment, and petitioner as well is also aged about 46 years as of now. Considering both the aspects, the only option remains for the petitioner would be to be regularized in service. The petitioner may have been appointed on a contractual basis initially, but a contractual appointment is always understood to be given for a period of time, as is always the essence of the contract. Continuation of more than 14 years till they do not indicate that there is an essence of time in the engagement of the petitioner. Be that as it may, petitioner is stated to be working against a sanctioned vacant post and he has served for more than 14 years. Even if we go by the spirit of the law laid down by the Supreme Court in Uma Devi, a legal right has accrued to the petitioner for being considered to be regularized in his service. In this circumstance, the petitioner, apart from his earlier representation, had also submitted a representation dated 16/1/2020 before the Director Higher Education Assam claiming regularization in service. We are of the view that in the factual circumstances in which the petitioner was appointed and is serving as a lecturer assistant professor in English in Habraghat Mahavidyalaya, a legal right has accrued in favor of the petitioner for an appropriate consideration by the Director of Higher Education towards his claim for regularization of his service. In view of the above, interest of justice will be met on a direction to the higher education to consider the representation and pass a reasoned order. Although paragraph 33 of the so-and-so as submitted by Gogoi may not be applicable, but we are of the view at least the spirit of the said judgment is required to be given a consideration. Question would arise that if the petitioner was appointed against a sanctioned vacant post due to procedure and due procedure was followed at the time of his appointment, whether appointment can still be considered to be an appointment on contractual basis instead of regular appointment, even after 16 years of being appointed. So, my lord, exactly on a perimeter fact situation, my lord, this was the view which a coordinate bench of this honorable court had taken. Now, my lord, my only submission is I am relying on 2-3 judgments of the Supreme Court, my lord, where the right of persons similar to the petitioner has been recognized, my lord. If forgive the extraction, my lord. Vikram Nath Sujako Bhagavad
But here, since when was the termination, Mr. Chaudhary?
20.
20?
20.
2020.
Let's file the petition, my lord.
Now,
But we served from 2007.
so this is you have been appointed against sanction post.
Yes, those
That
are
is-
sanctioned
That
posts.
is admitted position.
Yes,
And you have
that's why they have
admittedly,
advertised those posts, my lord.
admittedly you have served for how many?
13 years
13 years.
on the date of termination. Now, my lord, if we take
So
note
three basic admitted facts.
Yes.
Perhaps I'm saying admitted because I don't see anyone standing that side.
yes, my lord.
I will get time, then I when my
Okay.
term
No,
comes,
but
then-
is this admitted or not? The sanction
No,
post?
it is not admitted.
Not
That's why.
admitted.
Anyway, my lord will kindly have the judgment. Excellent. Vikram Nath. 2018, 8 SCC 238. These are all latest judgments, my lord. Please come to para 4 of the judgment, my lord, after referring to Uma Devi. The appellants, has a lordship got it, my lord?
Yes.
The appellants have approached this court arguing that the High Court erred in its judgment by failing to recognize the substantive nature of their duties, which align with regular employment rather than temporary or scheme-based role they were originally appointed for. Furthermore, their promotion by regularly constituted departmental promotion committee, the selection process they underwent, and the continuous nature of their service for over a quarter of a century underscored their argument for regularization, and that High Court has incorrectly applied the principles of the case of Uma Devi to their situation. Having heard arguments of both sides, the court believes that essence of employment and right thereof cannot be merely determined by the initial term of the appointment, when the actual course of employment has evolved significantly over time. The continuous service of the appellant in the capacity of regular employee, performing duties indistinguishable from those in the permanent post, and the selection through a process that mirrors that of a regular recruitment, constitute a substantive nature departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by DPC, and their sustained service for more than 25 years without any indication of temporary nature of their role being reaffirmed or duration of such temporary engagement being specified merits reconsideration of their employment status. The application of the judgment in Uma Devi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which appellants were employed have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on specific notification for vacancies and a subsequent circular followed by selection process involving written test and interview, which distinguishes their case from appointment through backdoor entry as discussed in the case of Uma Devi. Eventually, my lord, at para 8, in the light of the reasons recorded above, this court finds merit in the appellant's arguments and holds that their service conditions as evolved over time warrant a reclassification from temporary to regular status. The failure to recognize the substantive nature of their roles and their continuous service akin to permanent employee runs counter to the principles of equity, fairness, and intent behind the employment regulation. Accordingly, these appeals are allowed, the judgment of the High Court is set aside, and appellants are entitled to be considered for regularization in their respective posts. Now, my lord, let us come to the facts of the present case. There is no dispute that we are not backdoor entrants. It's not that, my lord, we have been picked up because my uncle is in Cockney.
There was an advertisement.
There was an advertisement. There was a procedure. At least a procedure which is consistent with Article 14 was followed. Yes, it was not an, my lord, it was not an advertisement inviting all and sundry, but it was a limited advertisement. Nevertheless, we participated.
There was a selection.
Then we served for 13 years.
And
during,
we were promoted.
And yes, and during that period, my lord, there was a promoted. Initially, we were academic counselor. Then we were made assistant professor. So, my lord, unlike in those cases where there are backdoor entries, we are not backdoor entries. At best,
if you see the nature,
yes,
and
we managed the department for 13 years. People were getting, my lord, placements. And that was a new subject which was introduced in 2004. We were recruited in 2004. There were vacancies were there. That's why it was advertised. Therefore, my lord, one has to notice the substantive nature of duties we perform. My lord, we perform election duties. We perform COVID-19 duties. We did everything. Election duties like any other normal employees. And we were teaching the students, my lord, we were the faculty members, but only tag was we are contractual. Now, what does the Uma Devi say, my lord? As a one-time measure, it should be that they should frame a scheme and regularize us. To that extent, my lord, Supreme Court has never said. In fact, my lord, in one of the judgment that Jammu and Kashmir's case, Chief Justice understood as he was then, my lord, in paragraph, I think 11, he said, Uma Devi is a restraint on the power of the court because it was seen that some of the constitutional courts were issuing direction for regularization. Then Supreme Court says, sorry, you can't. What you can do, you can ask the government to frame a scheme, or if they have a scheme, they should consider their case. That's why, my lord, in the Jammu and Kashmir case, where the Supreme Court clearly came up with that idea, my lord. Then, my lord, I will rely upon one more judgment, which is later in point. Earlier, my lord, we all know Amarendra Mahapatra. Then, my lord, where, my lord, Uma Devi was explained and reiterated. Then, Pratap Kishore Panda's case is there. Then, my lord, State of Jharkhand versus Kamal Prasad. These are all judgments are there, my lord, but I have placed a later judgment where Yes. A Jaguar copy নাই না? Huh? Sripal to আছে নেকি? My lord, there is one very risk, huh? A Jaguar to আহিছে নেকি?
2024 SCC online.
2025 SCC online 2 to 1 আহিছে নেকি? Huh? Notice to দিছা না? Wait, আহিছে. আহিছে. Sripal. ঠিক আছে. Milord will first have this Sripal Milord. 2025 SCC online SC 221. 2025 SCC online SC 221.
Yes.
These are all recent authorities, Milord, where the law in para 14, Milord. Para 14. The respondent employer places reliance on Uma Devi to contend that daily wage or temporary employees cannot claim permanent absorption in absence of statutory rules providing for such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield to justify exploitative engagement. Kindly see, Milord, to what extent the Honorable Supreme Court is that it cannot be used as a shield to justify exploitative engagement persisting over the years without employer undertaking legitimate recruitment. Given the record which shows no true contractor-based arrangement and a consistent need for permanent horticulture staff, the alleged asserted ban on fresh recruitment, though real, cannot justify indefinite daily wage status or continued unfair practice. So, my lord, in fact, the High Court understood Uma Devi in a particular way, and Supreme Court says the mandate in dicta in Uma Devi cannot be used as a shield to exploit people, my lord. Then, my lord, the next is the judgment 2000. My lord, 2024 SCC online SC 3826. Jago. This is not what is
3826. SCC online.
Jago versus Union of India. What is it?
2 number.
Give the year, it'll be easy for them to find it out.
2024 SCC online
2024 to
SC 3826.
2024 SSC online.
এই মাত্ৰ দিছিলো ন ওপৰতে তুলি মই দুইটাই
আৰু যে case laws আছে, give it to Mr. Kashyap. You keep it in your hand and then pass it. Yes.
Milord will kindly come to para 18.
Para?
18, Milord.
Yes.
The appellants have also established that individuals with lesser tenure or comparable role were regularized by the respondents. The counsel for the appellant had submitted a seniority list for employees working as multitasking staff published by the respondent department on 4/3/24, wherein the following employees were a part of the staff without the required educational qualification. So these were the Milord figures which were given.
Another distinguishing fact in your case is that it is not that you're not qualified or you
Yes.
don't have those
Yes.
qualifications. You have everything.
Everything. Otherwise.
You have everything otherwise. Because in most of those kind of
Yes,
cases,
some of the cases there were
very
lacking in
exigencies.
some of the other attributes.
Correct. That is not your situation
No,
here.
we stand in a much firmer footing, Milord, that way. Now please come to para 19.
And
Milord.
also through an advertised process.
Yes, advertised process. Now para 19, Milord. it is evident from the foregoing that appellant's role were not only essential, but also indistinguishable from those of the regular employee. Their sustained contribution over extended period coupled with absence of any adverse record warrant equitable treatment and regularization of their service. Denial of this benefit followed by their arbitrary termination amounts to manifest injustice and must be rectified. Kindly see the language which Supreme Court has used, my lord. It is well established that decision in Umadevi does not intend to penalize employee who have rendered long years of service fulfilling ongoing and necessary function of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirement. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service period, service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Binod Kumar, the one I read, my lord, it was held as so. So, my lord, the view presently or
Progressing.
yes, progressing, and my lord, the preponderance of judicial view is, my lord, Umadevi should not be treated as a deterrence.
Yes, because
Rather-
basically it was in the context of those kind of illegal appointments. Because that was rampantly going on at those times.
And it was seen, my lord, even constitutional courts are issuing direction for regularization. That's why, my lord, in the Jammu and Kashmir case, where Honorable Chief Justice Chandrasud said, my lord, this is a restraint on the power of the constitutional court. This is not a restraint on the power of the executive. Because power to frame a legitimate scheme, it always vests with the executive, my lord. Under Article 162,
This
when
is
it comes
stated
to
where?
my lord, the Jammu and Kashmir case, I think I'm
Yes,
having that.
I think you give me those three cases also, the Jammu Kashmir and
I'll give.
Jharkhand, I think. One is from Jharkhand.
Yes, Jharkhand is also there, my lord. Kamal Prasad and others.
You
You
can just
2014. Okay,
2014 7.
No, 2014 7 SCC condition 223. Oh, did sorry,
I have asked them to keep it
Yes,
with your
yes.
junior because it's easier for him to locate and pass it.
Yes,
Yes. This is Jharkhand.
yes.
Yes. Just give me the paragraph.
Para 30, my lord. Please come to para 30.
Yes.
Further, the learned senior counsel contends the core question involved in the case in hand are whether the service of respondent employees should have been considered for regularization by the state government, even though in the first instance they did not obtain selection through Public Service Commission, and on the second occasion they did not participate in the selection process. Whether they are entitled to claim regularization based only on the fact that they had worked for more than 10 years of service continuously with the appellants. He further submits that the High Court, considering the law declared by Umadevi at para 53 and also keeping in view the justice and good conscience, has granted the relief to respondent employees. The same cannot be termed either as erroneous or erroneous in law. Further, it is contended that the Division Bench of the High Court of Jharkhand has rightly rejected the contention urged by the Advocate General to the effect that persons who are appointed on ad hoc temporary basis had an opportunity to get another appointment in regular selection and they failed to participate in the selection process. Therefore, the same would not be a ground for appellants to refuse regularization of the service of the respondent employees, even after they had not availed such opportunity. The employer state government did not choose to dispense with their service, though there is no restraint order from the court. In the cases in hand, both the government of the state of Bihar and Jharkhand have continued the services of all the respondent employees for 10 years or more years, even after they failed to get appointed to the post on regular basis. Therefore, the principle laid down in Uma Devi would squarely apply in the case in hand in support of the respondent's employee. The submission made by the learned senior counsel on behalf of the appellant that regularization of the respondent employee in their service would deprive other eligible person from employment is wholly untenable in law, as the same would constitute not only discrimination but also deprivation of their livelihood, which is not legally permissible in law. Then Milord will kindly come to para 33. Lastly, it is submitted that there is a material distinction between filling up a vacant post by direct recruitment on one hand and regularization of the existing employees in their post by applying the decision in Uma Devi case, who have served for 10 years or more in the post to the appellant without intervention of any interim order by the court. Further, the learned senior counsel urges that principle which flows from the mandate of Article 14 and 21 is supported at para 53 of the Uma Devi. It is further contended that it is not the case of appointment as mentioned herein before, but it's a case of regularization. The only question for the latter is continuous service of the employees without intervention of the court over a period of 10 years. And this was the mandate in Milord Uma Devi. Then Milord will kindly come to paragraph 44(3). After referring to all the judgments, para 43 at page 241 towards the bottom, Milord. In view of the foregoing reason which we have assigned in this judgment, and in upholding the findings and reasons recorded by the division bench of the High Court in the impugned judgment, it cannot be said that findings and reasons recorded by the High Court in arriving at the conclusion on the contentious issue that arose for its consideration can be termed either as erroneous or error in law. In view of the foregoing reasons, we are inclined to conclude that the High Court was legally correct in extending the benefit of Uma Devi to the respondent employee. Therefore, we answer points 1, 2 in favor of the respondents. So therefore, my lord, let us not misconstrue the direction in my lord, Uma Devi. I would humbly submit it's an enabling provision, my lord. Yes, Uma Devi did not recognize the right of those whose appointments are illegal or who could secure a, my lord, backdoor entry. My lord, the Jammu and Kashmir case, well, one more case would be Amarendra Mohapatra.
Yes.
Amarendra Mohapatra. 2014 4 SCC. I'll refer to 3 paragraphs, my lord. 43, 44 and 45.
40,
43, 44 and 45.
five, 8, 3.
Sorry, 583. I'm sorry. As to what constitute an irregular appointment is no longer res integra. The decision of this court in ML Keshari has examined that question and explained the principle regarding regularization as enunciated in Uma Devi. Decision in that case summed up the following 3 essentials for regularization. Employees who have worked for 10 years or more, that they have so worked in duly sanctioned posts without the benefit or protection of interim order, they should have possessed the minimum qualifications stipulated for appointment. So these are the 3 conditions. Then please come to 44. It is nobody's case that degree holder junior engineers were not qualified for appointment as assistant engineer, even though they possess degree from recognized institution. It is nobody's case that they were not appointed against sanctioned posts. There were some debate as to the actual number of vacancies available from time to time, but we have no hesitation in holding that appointment made were at all relevant point of time against sanctioned posts. The information provided by Mr. Nageswar Rao, the learned additional Solicitor General, appearing for the state of Odisha, in fact suggests the number of vacancies were at all point of time more than the number of appointments made on ad hoc basis. It is also clear that each one of the degree holder has worked for more than 10 years ever since his appointment as ad hoc assistant engineer. It is in that view difficult to describe the appointment of the stipendary engineers on ad hoc to be illegal so as to fall beyond the purview of the scheme envisaged in Umadevi. The upshot of the above discussion is that not only because in Umadevi this court did not disturb the appointment already made or regularization granted, but also because decision itself permitted regularization in case of irregular appointments. The legislative enactment granting such regularization does not call for interference at this stage when those appointment or regularized have already started retiring, having served their respective departments in some cases for as long as 22 years. So, my lord, from all these authorities, what is clearly discernible is that Umadevi has always been construed as a judgment, my lord, which supports the view in favor of regularization. For a very oblique reason, my lord, at times we find arguments that Umadevi is coming in the way. I don't think, my lord, that's the correct position. My lord, I'm sorry that the Jammu and Kashmir judgment I'm not having.
No problem.
I'll
You can give it later.
Yes, I'll give it, my lord. Tomorrow in morning I'll give. That judgment is very important, my lord, where the court makes a distinction, where court says that no, it is a restraint on the power of the court, because it was seen that some
It
constitutional
is a restraint.
a restraint. Is a restraint on the power of the constitutional court to direct regularization. But what court can say? Court can always say consider it. There's no question of directing it. End of the day, my lord, actually, my lord will kindly see the legal thinking thought process always changes from time to time. My lord will kindly see in 80s we had seen case laws where hire and firing policy was adopted, where ad hoc appointments were made, then they were not thrown out. Then court says you can't do it. Then came you cannot replace one ad hoc by another. Now a time has come, my lord, posts are saturated. There are more applicants than, my lord, the number of posts. Therefore, now it is the time where Article 14 and 16 has to be strictly applied so that no unfairness takes place. Transparency is maintained in the selection process. In these circumstances, my lord, the court's task has become more difficult. Therefore, now court is said the best way to ensure transparency is to follow Article 14 and 16 scrupulously. Therefore, it changes, my lord. It's not a static idea. Now, my lord, Umadevi Supreme Court has given a window, my lord. We always construed other way. According to me, it's a window, my lord. Now, the government of the day can take advantage of this and stop this exploitative practice and regularize them. Give them the what does Article for 39, 43 envisages? It does only that only, my lord.
In this case also, what of course I have yet to hear
Yes.
the other side, but it appears that they could have issued regularized, or they could have appointed you
In fact, my lord,
through
it was almost reached a
because
stage.
correct. So instead of doing another
Now
re-advertisement
they
for
said
these
no,
posts,
now we will go only by advertisement and we'll give them weightage. And Lordship knows a person who had joined in 2007, if he has to compete with a new student of Millard in
and these are not
2020,
cases of some daily wage employees.
yes.
They're
So therefore,
teachers.
my humble submission is, Millard,
They're
having
academicians.
regard to the facts of the case, government should consider in pursuant to the earlier exercise which they undertook, that should be taken to a logical end, That is
No,
my
because
humble
it looks like perhaps their services have been exploited for 14 years. They were given promotion.
See, nowadays, even state of Assam has recently, of course, now the judgments have come. Now some teachers have been appointed as tutor and they are paid a salary of 15,000 Malko. Is it not exploitative, Malko? Our division bench has said, no, you cannot. You must give them minimum of the pay
A
scale.
driver will also get more than that.
So, therefore, is it not exploitative? Where is the choice for the people? Even 15,000 also they will have to work. Otherwise, their family they cannot run their family. These are the aspects, my lord. End of the day, welfare state must take note of, my lord. And recently, my lord, in case of social welfare department, a coordinate bench has passed a similar order, my lord. Like I appeared in this case, the social welfare department, my lord, here in Lucknow. More citation to co today. 2024 SCC online Guwahati 1880. Para 34, my lord. In the present case, as noted above, although the post of CDPOs are to be filled up to Assam Public Service Commission, due to exigencies involved with the relevant
Para?
point of para 34, my lord.
Yes, the
In the
last
present
second
case,
last
as
para.
noted above, although the post of CDPOs are to be filled up to Assam Public Service Commission, due to exigencies involved at the relevant point of time, the appointment of the petitioners have been made by following a due process of selection, wherein other eligible interested candidates had also participated. In my view, respondent authorities may consider framing an appropriate regularization scheme as the executive or the legislature is competent to frame such a scheme. My lord, in this case, that Jammu and Kashmir judgment is referred, my lord. I placed that now I remember. Yes. Yes, please come to, my lord, paragraph number 31, my lord. My lord, paragraph 31, just keep over one page, my lord, then come to that para 11 in between. That is the Jammu and Kashmir case. This quoted para 11 somewhere in the middle. Has your lordship got it, my lord?
Oh, yes, yes.
Para 31, this page numbers and page 11, my lord. Please come to
I
page
think-
11.
Huh?
Page 11 on top.
Yes, yes, I have got it.
Yes.
In the case of district bar
Yes, that
association.
is the judgment. The Honorable Supreme Court has observed and held, which are quoted herein below. The decision in Umadevi dealt firstly with right claim by temporary employee to be regularized in service on the basis of long continuation, legitimate expedition, employment under the state and directive principle. The second salient question which the Constitution bench was called upon to answer was whether court would be justified in issuing a direction for regularization based on such features such as equality and long spell of service. On both counts, Constitution bench held against the temporary employee. However, that is important. Umadevi is not an authority for the proposition that executive or legislature cannot frame a scheme for regularization. Umadevi does not denude the state or its instrumentalities from framing a scheme for regularization in para 53, etc. So in para 11, this is what Supreme Court says. It does not denude the executive of its power. So this in this case, my lord, these CDPOs were recruited, my lord, not through APSC, but in their case, they have been asked to consider their case for regularization. So, my lord, I will also be praying for a similar direction as is given in this Hiren Chandra Nath's case. It's a very recent judgment, my lord. I think about 6 months.
Now, here,
that
what
is-
has happened to the advertisement?
My lord, pursuant to the advertisement, three persons have been recruited, whom my learned friend Mr. J. Roy appears, my lord. Even if without disturbing them also, there are vacancies. My lord. So that's why, my lord,
Where
my learned
do
friend
we
did
get
not take the
the
trouble of arguing.
where do we get the vacancy position?
Yes. If your lordship will kindly come to the first case, my lord.
এখানে লাইন ডেস্ক্রিপ্ট Mr. Roy, you are representing those 7, 8, 9, the three candidates. There are only three candidates who have been selected. A point you are working.
Nineteen. 1 minute. এইটো কি আছিলে বাবাটো? Lord, regarding this vacancy position,
Mr. Das, this is a unique case where the
where
selected candidate is helping the terminated candidate. Quite an unique feature. You don't get to see it.
Because my learned friend said.
I understood. I understood.
So Mr. Roy is relaxed.
termination my lord, in the other case,
Yes.
they have not been terminated, and the result of that advertisement is also not true as yet. But regarding in this case, I'll come up in the form of a chart, my lord,
Very well.
giving the
Very well.
exact
Just give
position.
everything.
At the time of my reply, I'll
Yes,
give that.
yes, yes. Yes.
So my lord, my argument will be of two repetition, 9474, 938. But your lordship can look to 938. Because
Yes, I have
937, because my lord, all the judgments I am also holding all the judgments. But the facts is very important to know the facts of the case. Whether all the judgment which are cited, and we have seen the judgment of the Supreme Court, right from Uma Devi, Keshri judgment, three important aspects are there. One is that it has to be, qualification has to be there. Qualification, initial entry qualification, valid sanction force, and whether they work for more than 10 years. One-time measure, the state can do it. One-time measure by the state. But three conditions are very important. Whether these three conditions are fulfilled in this case. Because Lordship has asked that whether it is a sanction post, whether they are qualified or not, they have the qualification at the initial entry of the service. I'll tell you, Lordship, that it was a cotton college earlier. After cotton college, all these, my lord, there was an advertisement, but I will show it. That one advertisement they have annexed in somewhere in 2008. But kindly see that advertisement, academic counselor. That advertisement was issued by the principal. In our state, there is a rule. The rule is education service rules, where advertises are being made by the through an APSC. Through an APSC advertising made. Your lordship knows earlier 3F appointments are being made, but those are all temporary. Ultimately, it has to be through an advertisement, regular appointments are being made. Here, kindly see what is the advertisement that has been made. Advertisement made by the principal of the college, and that too a post which is called an academic counselor. There is no post as assistant professor. They were not promoted. I'll show it. It is my stand. They were redesignated subsequently. Not a promotion has taken place. It was an academic counselor.
Same pay scale.
Yes, they redesignated. They were redesignated as assistant professor. Now, the very interesting.
The salary remained the same.
Yes.
No, salary doesn't.
From they got salary from the tuition fees. Not this advertisement was made in 2008 for the filling up the post of academic counselor, and from the fees, from the tuition fees which they have collected, their salaries were paid. Not from the salary of the state government. Because if there is a salary from the state government, there is an advertisement for those posts. Where are the advertisement for the post under Rule 6 of the Assam Education Service Rule? There has to be an advertisement. There is no through APSC. It's not done. So kindly see point 1. So far as it is not a valid sanction post. Number 2, it is not through a selection process, which is.
Why are you saying it's not a sanction post?
It is not a valid sanction. Where is the saving? Because it has to be through a state government, a valid sanction post. It is a principal who has advertised.
That I've understood.
Yes.
But otherwise the post is there, sanction post.
No, what post?
Academic counselor, that post is not there.
There is no such post as academic counsel that has been created by the principal. Where is that post? Under the rules, it starts from assistant professor. So this is academic.
So what was this academic
counselor, and my lord will kindly see. I could have very well understood the salary come from the state, It is only from the tuition fees is collected and they are being paid. They may, and time to time their services are being extended, time to time. And most important, when the advertisement, they continued to a certain period. 19/6/2019, there was the advertisement issued now by the state. They issued the advertisement by the Cotton University. It was Cotton College. There are Cotton College State University, then the Cotton University has taken it. Then there was the advertisement on 19/6/2019. 19/6/2019. Now, there were 4 posts to be filled up. My lord will kindly note down. 3 is a reserve post, 1 is unreserved post. 3, well, I'll show it. I'll just pointing out, I'll show it because facts is very important. 3 is reserve post, 1 is unreserved post, advertisement of 19/6/2019 by the Cotton University. Now, EC takes a resolution when it goes to Cotton University. They takes a resolution. Your lordship has seen the resolution that there is no question of any entertainment so far as the regulation of service is concerned. You can participate. There will be a regular selection process. You will give weightage will be given to you because you worked. Now, in pursuance to that, there is an advertisement of 19/6/2019. 1, they did not challenge that executive council decision which they have taken that no contractual we will not regularize the service. They did not challenge as on date also. Number 2, there is an advertisement which they participated. Now, lordship will kindly say they participated. They participated. And maybe they did not qualify because petition number 1 and 2, they are overage. So their case was not considered. Petitioner number 3, he did not meet the criteria, requisite criteria. The cutoff mark he did not. Now, number 4 and 5 did not have that the required qualification. Net SLET, PhD, that was required, they did not have. So even as on date 4 and 5 doesn't have. So my lord, all this has to be looked into. That's why I said all the judgments are there. I have also looked in judgment, but they did not have 4 and 5 did not have. Can your lordship ask for can mandamus can be said no, their services can be regularized. 4 and 5 did not have the qualification as on date. 1 and 2 participated, but they were overage. 4 also did not meet the criteria. Once you fail, advertisement was issued, you participated, you fail. Thereafter, you are coming to a court and seeking for regulation. 2000, their qualification, which they have net SLET, is 1 is 15, PhD, only PhD, 1 is 2015, 1 is 2017, and 1 is 2018. As on date of entry, my lord, they did not have the required qualification.
PhD.
Yes. PhD, net SLET, they did not have. PhD, net SLET, they did not have. So let us say for an argument's sake, let us say that it was advertised. Even then you did not have the qualification. Can your lordship consider where you did not have the qualification at the initial entry? You do not have the qualification. So how the judgment will help? All the judgment what I have heard and what I have gone through it, we also carry. These 3 important criteria has to be looked into it. MLKC judgment your lordship has seen. That's what they said after Uma Devi. Kindly see now specific environment 10 we have taken. Kindly see my 938. What is their case? 938. And what is the prayer they sought for? Kindly take 938.
Yes, I have it.
Yes. Read at page 23.
Yes, the prayer.
Prayer.
This I have seen, yes. Termination, advertisement, regularization.
They were continuing, extension was granted from time to time. Then we terminated on 6/2/2020.
Mr. Das, just 1 second.
Yeah.
So at the time when this writ petition 938 was filed,
Yes.
this advertisement already they had participated and they had.
They participated. 19/6/2019 is the advertisement. and they participated.
So,
No,
alright,
I'll
you
tell
read,
no, no,
you wanted to
no,
read
one
it,
second.
just read.
Well, I'll clarify this
Huh.
because there is a confusion.
Huh.
9474, that was the first writ petition.
That's
they
the
came up.
advertisement.
That was the advertisement. They came up before the court. They said that yes, our services should be regularized. We have put in this years of service. They challenged the advertisement, but they participated. Already they participated.
No.
Where yes, they participated.
Leave was given.
But when the names were not shortlisted, my lord, then they came and filed this writ petition 9474.
Clear.
In the
Now-
first writ petition.
Yes.
When their names are not shortlisted, they came up and before the High Court, first writ petition was filed. Now, the second writ, by the time, my lord, in person to advertisement, the selection has taken place. They did not meet the criteria, selection criteria. They participated, they failed. Now, in the meantime, my learned friend's client was already appointed. Now, there was an order passed by the High Court. When they came to this court, there is an order passed by the High Court. If your lordship kindly see 9474 order.
No, why? What is the criteria that the petitioners have not met with? You said 1 and 2
1 and 2 is
overage.
overage.
1 and 2 is
1 and 2
overage.
is overage.
That is because after so many, that overage can be understood.
Yes.
1 and 2 overage.
But your lordship, they have to
No,
apply
I
for
am
condo.
just simply saying it because
Yes.
prior to this, you have not made any advertisement.
Yes.
Huh?
No, we have.
Prior to this,
Yes. 2013.
they did not.
Yes, they did not. One
Then
participated.
you give that list. huh?
I'll give it. Yes.
Please
Yes.
give a note from your side also where you clarify how many advertisements.
Yes.
Against which advertisement, if any of the petitioner appeared, if appeared, what happened, all these details has to come, huh? Mr. Nair?
No, it is there in our.
No, that's all right, but Mr. Nair, you put it in the note, all these specific instant, this thing.
So your lordship. was
And
noting down-
Mr. Das, what
Your
about
lordship
the
was noting down.
1 and 2 overage?
Overage.
Yes,
Petition number 3 didn't meet the required mark for shortlisting.
mark.
And
Then,
petition number 4 and 5 did not have the qualification, no slate, no net and slate.
no net and slab.
Yes. As on date also 4 and 5 doesn't have. It doesn't have as on date.
Okay.
So if you see now, the order that has been passed by the court. Page.
And Mr. Nair, what about that other, the other petition? There also, how many petitions?
Two petitioners.
Two petitioners.
Separate department. This
Na-
particular.
And those two petitioners were, had participated
Yes,
and did not meet the criteria. What criteria?
one of the overage.
Overage, both overage.
But my lord, pursuant to orders from this court, they were allowed to sit in the interview. They were interviewed.
Okay.
The records were there.
So after interview,
My lord, the record is there. We had declared the result of only one because both the candidates, both the petitioners are unreserved. There were two posts. One is EWS and the other is unreserved. The EWS post, my lord, we had to declare, but the unreserved post, we have not declared.
not declared.
My lord, it's in seal.
There is some stay.
My lord, stay in the other petition.
This is my line. So kindly take up 938.
Yeah, I have
938, please see my affidavit which has been filed. See paragraph 7. Paragraph 7. Just that
Affidavit in
regard
opposition.
in 938, page 107.
107.
107, please see para 7.
Yes.
That in regard to the statement made para 3 of the writ petition, deponents said the petitioner working as contractual teachers, but they were initially engaged as academic counselor on ad hoc basis and then designated as assistant professor from 2012. They were not engaged against vacant or sanctioned posts, and the salaries were paid from the fees collected from self-financed courses in the Computer Science and Information Technology Department. Deponent further begs to state, petitioner 1, 2 and 3 had participated in the selection process initiated by the advertisement dated 19/6/2019. However, names on the petitioner 1 and 2 could not be shortlisted due to crossing the upper age limit for the post, and the petition number 3 has secured less mark than the last shortlisted candidate. Furthermore, the petition number 4 and 5 did not apply in terms of the aforesaid advertisement dated 19/6/2019, and they admittedly do not meet the eligibility criteria for appointment as assistant professor. Now, my lord will kindly see this. Paragraph 9.
Yes.
Then in regard to statement, deponent begs to reiterate the petitioner were initially engaged as academic counselor on ad hoc basis for specific period, then designated assistant counselor contract 2012 against non-sanctioned post, and they were paid remuneration for the fees collected so and so. Further, the engagement were not continuous or in extension of the services, and there were long breaks in the services which cannot be said to be artificial break. Moreover, it was a condition for the engagement. They could not claim regulation in future for their contractual engagement. Now, Your Lordship looks into it. Hundred and 3, my lord.
Yes.
Page 103. Paragraph Q, my lord. Q. 103, paragraph Q. Paragraph Q.
Yes.
The petition number 1, 2, and 3 did not have the requisite qualification for having PhD net slap for the post of assistant professor when they were initially engaged as academic counselor or assistant professor contractual in Cotton College. Petitioner 1 qualified for PhD in the year 2015. Petition number 2 qualified for PhD in the year 2017. Petition number 3 qualified for PhD in the year 2018. Petition number 4 and 5 do not have PhD net slap and still do not satisfy the UGC norm for recruitment assistant professor in an university. So, if you please take into consideration of his PhD in 2015 and 17 and subsequently 18 in respect of 3, even it doesn't, because 2015, how many years of service? Your initial entry, you did not have that qualification. You did not have that qualification. Sanction, why I am saying there has to be sanction from the state government. Where is that? Principle of his own. He has advertised, and that kindly see his advertisement. One advertisement they have annexed. Therefore, the advertisement, your lordship will find in 938, page 29. Kindly see. Date is 19th of
Who's appearing for the state?
February.
Mr. Gogoi, you'll have to clarify this, whether these posts that the petitioners were holding when initially it was advertised ad hoc, was it against sanctioned posts they were initially appointed or what? And because it is some academic counselor.
No, it's not a sanction post.
Anyway, I am just letting you know.
Please see page 20.
And your affidavit is on record.
Please see page 29. Page 29 of 938.
Yes, the advertisement.
See on the top, 19th of February 2008. One of the advertisement. This is by the office of the principal Cotton College.
Why are you saying one of the advertisement? There were more advertisements.
More advertisement, but we don't have that advertisement either. It has been annexed, not been annexed.
No,
Because at that time,
is this not the advertisement
the
against
advertisement.
which these four the four petitioners have appeared? This page 29.
Different advertisement. This is one of the advertisements. No, this is what my instruction is. We do not know whether any other advertisements are there or not. We only know about this advertisement. Because at that time it was Cotton College. If it was under the government, we are representing Cotton University when it was taken over. It was in 2017, Cotton University was taken over. 2017? 17.
No, because you see, if this is of 2008.
Yes.
And then
If you see at page 30, see page 30.
2007.
This is the
Okay.
way. So, up to, if your lordship looks
So
into it,
therefore, this page 30 document cannot be said it is pursuant to the
no, that is very clear.
advertisement
See
at
page
page
31,
29.
page 31,
They're all 2007.
no, 2008. One is 19/3, 2008. First,
This is 6/8. So this is after.
6/8.
This is
First-
after that advertisement.
Yes, first, Anupam. Prior to the advertisement is when 19 February 2008. 19 February, see page,
No,
page
that I
29.
know.
Page 29.
Correct. Page 29 is 19 to 2008.
But
And this the appointment of petitioner
Anupam
number
Das.
1 is prior to the
that's
advertisement.
right.
However, petitioner 2 is after.
This is
Petitioner
yes,
3
after.
is after.
Yes,
Petitioner 4 is after.
yes.
Correct.
5 also is
5 is also after.
kindly see the dates.
9.
And if you see the advertisement, it was only for ad hoc for one post. What does it?
Is it one post?
What does it?
Where is it given one post? One post is not mentioned.
We have stated in the affidavit, my learned friend is saying.
No, but the
Yes.
advertisement doesn't show one post. Those records are not there.
Department. of-
Records will not be there, na, Mr. Das?
Records.
Because that time it was Cotton College.
College. If you see at page 115, 115 of our affidavit, for a moment, please take 115.
But Mr. Chaudhary, this petitioner number 1 appears to be,
Yes.
there is some confusion here because that you have to clarify because I was given the impression that all these petitions, only for that, the rest appears to be later.
Is the only one which we found in. Only in our records, my learned friend is saying only one advertisement we got, that is page 150.
115
of my affidavit.
of your
115.
affidavit. Let's see that.
115. Yeah, yeah. 14/11/2008. The signature is there, 14/11/2008.
115.
115 of the affidavit. R1A.
No, page R1A, yes. That is an advertisement.
This is the office of the principal.
Yes, I have it.
On the top. Application along with all names are invited from the interested candidates. For the
Academic
post of
counselor.
academic counselor, Lordship got it? Ad hoc in the Department of Computer Science and eligibility. And now applicant along with the names are invited for interested candidates, so and so. And if you see his signature with 14/11/2008. And what we had is the mark sheet at page 116. This is a biodata chart. If you
This
see,
also doesn't indicate how many posts.
no, it doesn't indicate. Now, if you see the next page, kindly see the next page at 117.
Yes.
That is at page 117, appointment of academic counselor, enclosing order of merit, Dushanto Dotto. The first nominee may be appointed as academic counselor. If the Lordship looks into it. He is not a petitioner in this case. He is not the petitioner.
No, but with government not have a say?
And
Government will have a say initially. As regard that advertisement, sanction post, what and whether one post, more post. I think, how come government has not filed an affidavit then? Because you don't have the records. Now suppose we need, because you see, if this court has to do the exercise to find out whether the petitioners are entitled at this stage for regularization or not, then obviously the court has to test from the initial time whether these, first of all, whether it's illegal or irregular. These are the two aspects, correct?
Yes.
I don't think there is any
Yes,
dispute to that proposition.
Yes.
Now, for illegal, there are certain parameters which has to be looked into. Suppose all of those parameters are met with,
Yes.
then whether it can be said because of some lapses irregular. I think this is
Yes.
too correct. Only then one can.
But
To go through
forget-
that
but
exercise.
your lordship will definitely go into it. The initial, how there is advertisement, whether there is any stake of the state, what is the role of the state, that has to be looked into it. But initial entry, your lordship is now, by your affidavit is very clear. If you go to the judgment of the Supreme Court,
Qualifications.
they didn't meet. It's apparently on the face of it. They didn't have the qualification. Can this court now consider service for regulation? My lord, 10 years.
One
maybe-
decision of the Supreme Court where clearly it is mentioned that even for salaries, if the initial appointment is illegal without with qualification, advertisement or anything, even salaries cannot be given by a constitutional court. There's one decision of the apex court. Ask your juniors to see if they can find it out. That para 17 of that judgment. I remember the paragraph, but I have forgotten the citation of that case. Whatever relief, that if it's illegal appointment, if the qualification is not there, even salaries will not be for, because there are many cases where they come for salaries. That case was for salaries of one batch of ad hoc employees. In that context, it was given.
But the executive council decision also they have not challenged that. Your lordship has seen. This is a page of my affidavit, which I have brought.
They have challenged the
court.
termination and
They-
they have a
Because
prayer
they-
for regularization.
See, my lord, that is the main. In pursuance to that only there was an advertisement for the post. They said they will not regularize the service. Kindly see that.
But that's all right. It's a technical point.
Yes.
I've taken note of your point because the termination is because of the.
Yes.
But Mr. Das, the termination is not an immediate consequence of that resolution, is it? Because that resolution
No.
is only for regularization.
No.
The proposals of the regularizations have been turned down. And said
Yes.
that no, there is no question of regularizing. If you want, you participate.
So in pursuance of that, they participated because they are not eligible 4 and 5. They could not
So
participate
in that
because they doesn't
context,
have.
in that
Now,
context, you are saying
now-
that they have not
No.
challenged the resolution.
Yes. And they are seeking regulation of the service.
Okay.
Now 4 and 5. Yes. Because if you see the order, see the order 9474, there is an order 9474. Order of the High Court. Kindly see, they will continue till the regular selection is appointment is
9474
84 Milo. 938, kindly see.
938.
938 at page 84. No? 84. 81, 9, See at page 84. With regard, at page 84.
Yes.
With regard to this subject and reference above, I am to inform you that you would not be required to continue as Assistant Professor, Department of Computer Science. You are requested to kindly hand over all official documents in possession, head of department. This has been issued in accordance with the directives of the Honorable Guwahati High Court, wide order dated 28th of December 2019 for case number WPC and to approval of the Honorable Vice Chancellor, Cotton University, so and so, so and so.
And this reference, that office order 2120 is what?
2-1. That is an extension order. Extension of the contract, it was till 31/3/2000.
So further extension not given.
31/3/2020. And once they were appointed, Roy's client was appointed. We just paid, but 6/2/2020 they were terminated. and up to 31/3/2020 we pay, but they were not in the office. Once they were appointed, my lord, because pursuant to the order passed by this court, in a miscase which they have filed, they will pay salary they have sought for paying of the salary. Court said yes, very well, salary up to 31 because you have given an extension till 31/3/2020. So maybe you have terminated a service, but they are entitled to get the salary till 31/3/2020 till they are appointed. So in pursuant to the advertisement of 19/6/2019, they were appointed. Now the question is here, you participated, you failed. Now you come to the court seeking regulation of service. Let us see what is your regulation of service. Regulation of service also, you don't meet the criteria. You don't have that, the requisite qualification you don't have. Neither it is sanctioned post. If the state government can show that, yes, let us say that it is a sanctioned post, but where is your qualification? Where is the initial entry into service? Academic counselor. Let us say the academic counselor is also a post, but you don't have the requisite qualification. How your lordship will look into this issue?
What are the qualifications for academic counselor?
It is written here. Kindly see. Academic counselor. Advertisement, it is, yes. There is no. Kindly see.
Where?
At page 29. Advertisement.
MSc, MTech, MCA in computer science.
Because.
And for assistant
yes,
teacher?
That assistant
Professor.
Yes.
What is the qualification?
55.
55 in master's degree plus let all PhD.
Yes.
That right to.
Yes.
Not right to my UGC.
UGC, correct,
regulation.
UGC. That's
So-
56.
Yes.
56 and that,
The act.
and then the rules and the.
So if your lordship, now these are all under the UGC regulation. So how can you seek for regulation on the basis that you have been continuing serving from this particular, from 2008 onwards? How? On what basis? And UGC, your lordship knows, they have got selection. That is why they didn't consider. We cannot regularize your service. You are all contractual. They know that initial entry into service also only MSc, MTech, nothing to do with. You don't have the requisite qualification also. You have, now they are taking the advantage that no, we are assistant professor. You are is designated assistant professor, but you don't have that qualification.
Let's see that order again. Assistant professor order.
Yes.
Page 40.
Page 40.
Yes, 40. Yes.
40.
With the approval.
Yes. That we don't have that. Prior to that, it is Cotton College.
Huh?
2012.
Yes. This is
Yes.
Cotton University.
Yes, Cotton University.
Page 40. Yes.
2020. Yes. But redesignation, I have been told it was done by Cotton College. The then Cotton College.
No, where is
Which
that?
you don't have.
Where is that?
Don't have.
That you
have
don't.
that.
But
You don't
this
have.
is done by you, Cotton
Yes,
University.
Yes.
So,
We continued it.
so there must be some documents available because you continued.
Yes.
On what basis did you continue? Academic registrar is there.
We'll see it.
Hmm?
My eyes.
Yes,
my-
Mr. Nair, have a look at that. Mr. Das, can you please this order once? That
Which-
page 40.
Page 40.
I just want to see it once again.
With the approval of the Vice Chancellor, undersigned is pleased to offer appointment Assistant Professor Contractual to Anupam Das and Department of Computers and IT with following terms and conditions. The appointment is purely temporary on contractual basis for a period with effect from date of joining till 31st of March 2020. Incumbent will receive a monthly fixed remuneration of 34,000 per engagement only. No other allowances. 4. Incumbent will have no right for claiming appointment either regularly or on contractual basis after expiry of the contractual period of engagement. Incumbent will not have any claim towards so-and-so PF gratuity, so-and-so. 7. Abide by rules and regulation university, indicate his acceptance of so-and-so. terms and conditions, offer appointment, joining letter, hand over the same to undersign. Contractual appointment may be terminated at any point of time by the university if the service is found unsatisfactory or the service no longer required by the university. So these are the office order which was issued.
I think a little note also about this whole cotton college, cotton university, state something, what was that? And then
Just note
all
down
these things, huh?
one thing, my lords, 2011 cotton, 2000. Yes,
Put that
Cotton
in the
College
note.
State University was formed in 2011
Yes.
and 2017 Cotton University.
2017, no?
Yes. Merging Cotton College and Cotton College State University. Merging.
I'm sure during at
Cotton
the
College
time
was
of
after.
merging, you must have had some records of how these academic counselors have been brought into the service,
And I
because otherwise you can't continue them.
and I have been told by my learned friend who has been appointed D-Den by Cotton College, their salary was given by the state government. By state, Cotton College. Other who were working under Cotton College, then their salary are being disbursed by the state government.
And these are from the tuition fees.
No, these were from tuition fees. But even regular appointment, which was made under the rules, and they were appointed by Cotton College, their salary was paid by the state. But here, their salary was not, they were not appointed by under the rules. It is by way of advertisement for academic counselor. So it is from a tuition fees they were paid. And Cotton University, employees are from university funds. Salaries. But even today, if some employees is working under D-Den Cotton College, the salaries are being paid by the state. Even they are working in Cotton University, their salaries are being paid. Artsward. Yes. And after that, when your lordship has seen those upon just now I read, at page 62, if your lordship see for time being, see 62 page of this. 938.
Yes, by Rupa.
See.
I don't think there would be time for the other 4 matters which are pending. So if you want a specific, if both parties are there, you may say, if you want a particular date or something, you may just.
Well, there is one item. It is not a very long matter, my lord. Item number 35, can it be on Tuesday next, my lord?
All right, 35 on Tuesday. Okay, just mention it to the court master.
Yes.
Yes. Mr. Das?
Yes, sir. Please see page 62. Well, facts they have to be very clear. That's why I am showing it. Page 62, after the order 2020, that order your lordship said, now you please read that order.
Yes,
See
that
that
is
62.
Yes.
This is on 22/11/2018. It was
This
approved.
is on 20.
Kindly see last. The EC suggested that all the contractual teacher appointed by Artswell, Cotton College and Cotton College State University across various disciplinary university be encouraged to apply against the advertisements regular posts. The selection and recruitment of teacher would be in accordance with the UGC regulations and Cotton University Act 2017 and their experience may be given weightage as per rule. In pursuance to this advertisement issued at page 63. Kindly see page 63. Now please
Just one sec.
Yes.
Yes. Then they applied
Now this
again
is
63,
yes. This is the advertisement.
but did not
Appointed-
got cleared.
This is what. And kindly see your lordship was asking which post.
And this page 63 was under challenge in that other one, not the first round.
No, this was challenge. This EC.
This
No, this is not been challenge.
This
EC
is-
regulation.
No,
advertisement challenge.
63.
Yes,
Page
advertisement.
63.
Yes, challenge. prior to the challenging this,
There were,
participated.
there were other
They
evidence.
were, they participated. They
In
participated.
earlier.
Yes,
evidence.
947. And yes, it will, no? They were not shortlisted. Only they came to know they were not still shortlisted, then they challenged it by way of the first writ petition, which was filed. And if you see at page 65, these are the number of posts. Your Lordship was asking which are number of posts. See at page 65, at serial number 10. Serial number 10. See page serial number 10.
4.
Yes.
Number of vacancies.
Yes. Breakup is given. One unreserved, only one unreserved, one EWS, one SC, one STH.
This Mr. Chaudhary has shown.
Yes.
He has shown.
But all the petitioner, all
He had mentioned out of the 4, 3 are reserved and 1 unreserved.
So all these petitioners are all unreserved. See at page 75, where I was talking about a miscase which was filed by them, right? Original first writ petition, page 70, first writ petition.
Yes.
See the order, kindly see the last. In the interim, it is directed that till regular appointment is made, the petitioner may be allowed to continue in their services. So once they were appointed, so we decided to terminate the service. But however, they filed a miscase before the court, their salary was paid, but they were not continued after 31/3/2020. But page 73 is the case number. Kindly see 73. Page 73, the operative portion I read 9474. That was the first writ petition. This is also for the lordship 9474.
Yes.
Item 10. So this is the factual position of the case, my lord. Page 76. This is a shortlisted candidate, page 76.
Yes.
Name of the shortlisted. Huh? Oh, what way? Website link of the shortlist candidate. Website link. 76. They saw the website link. They found that their name was not there in the website link. So hence they filed the writ petition before this on, right? 76.
Yes.
So this is the facts of the case now.
Lord, there is one fact needs to be clarified, my lord. In the first writ petition, we challenged the advertisement. Then court gave us liberty to
That page
participate.
63
First one, my lord. 19. First case to 19. Their liberty was given, that's why we participated. So, yes.
Sure. It is only after finding that they had not been shortlisted.
No, there
Shortlisted
is.
for
And we'll get that
Anyway,
answer.
you see, this
Number
case
one.
anyway is not going to finish right away. So
Secondly,
get
my
a
lord,
clarification to that.
And
Mr.
secondly, my
Chaudhary,
lord,
in case you have got that liberty, then you just point out that
I'll do that.
on the next day.
Secondly, my lord, my learned friend has made a submission that we do not have the qualification. Yes, QA 4 and 5 we don't have, but 1, 2, 3 has.
That's next letter is not there.
No, it's there. 4 and 5 is not there.
That's what I'm saying.
Ah.
Because they
But
don't have
1,
the
2,
next
3,
letter.
1, 2, 3, they have all the qualifications.
Yes, because 3, I think, because of some marks. And 1 and 2
secondly, my
because of
lord,
age.
and secondly, my lord, age.
Age.
My lord, most importantly, UGC regulation of 2009 do not prescribe any age for assistant professor. Is there, my lord? My lord, end of the day, lordship will have to test our claim with reference to ML Kesari's 3 proposition. Whether we have worked for 10 years, whether the post are sanctioned, whether we worked on the strength of any interim order. These are the 3 considerations. And we'll show,
I think that the main thing is you're right about the initial, but
Yes.
the criteria is whether what was the nature of your appointment, number
Yes.
one. On what basis?
yes.
Suppose there was a valid advertisement, there was a sanction post, then there is no difficulty to
Precisely.
say that everything is there. Maybe some rules may not have been, that is a different aspect. Correct?
Correct.
But suppose, first of all, this advertisement, it appears is for a post, which now an
No, my lord,
impression
it
is being
it is
given.
not for one post, my lord.
Correct, no, but an impression is given that this academic counselor
Ah.
did not exist at that time.
No,
An
academic,
impression is being given
Ah.
because I'm hoping you will throw light in your reply.
yes.
Because this is what you see,
Will-
ultimately,
will-
I will have to author a judgment.
What I
and I'll
propose
have
to do, my lord, I'll
Yes.
come up with a chart where I'll try to bring
Yes,
out
no,
everything.
and you have to clarify these submissions.
Yes,
So
I've
that is
taken
why I'm
note.
just indicating so that you can
I have taken note.
take note of what is going on in the mind of the court also. Because the submission has come that the academic counselor never existed earlier. Then that these are not sanctioned posts. Government has not sanctioned. These are, and they have pleaded also. They have
My lord,
pleaded all that.
nomenclature does not make any
Whatever.
difference. Yes.
You
Anyway, I'll come up with that reply.
you react on the next date, but just for your
Yes, yes.
Making it clear to my learned friends, he said, they 1, 2, 3 did not have the net slate as on date. 1, 2, 3 only qualified their PhD only in 2015, 17, 18. 15, 17, and 18. We have mentioned.
so therefore that relaxation, because if you have
15th.
PhD after I think that UGC, Mr. Gogoi, where have you gone? Which is that OM which says that if you have PhD, then you can be exempted from net slate.
Net slate.
Yes.
And in your case only the other day I gave a judgment, Mr. Gogoi, in your case I think.
But your lordship judgment, I have looked into their judgment also.
Sorry?
Kishore Dekha judgment. I
Yes,
have
yes.
looked into their judgment also.
This is a PhD. When did they obtain PhD?
2015, one is 2017 and one is 2018.
2017,
15.
15.
Petitioner 1
15,
is
7.
2015.
I'm just making a rough note
Yes,
here,
yes.
but you
2000, petitioner 1 is 2015. Petitioner 2 is 2017. Petitioner 3 is 2018.
yes. When can we continue?
Before vacation, it may not be possible.
It will do power years of. That's right. We should finish it off.
This court is
Yes.
ready next week also.
Ready. Next week?
Thursday also.
Thursday on.
Next week Thursday. Huh? This court is not taking motion matters. Unless something is given, I don't know, but perhaps if Mr. Chaudhary, he has a valid point. If next week is declared motion, then perhaps you all will get busier.
Let us keep it for Thursday, my lord. In case we cannot make it, we'll make a request.
This Thursday?
The next Thursday.
Next Thursday.
Next Thursday, कोई
Thursday or Wednesday, में any day, my lord.
Thursday perhaps should be easier because
Yes, let it be Thursday.
otherwise a lot of admissions are there on the miscellaneous date, then both matters
Plus,
get
anyway,
suffered.
2 days will be left, therefore there will be a lot of rush also.
Arvata matter is actually Friday, Friday, ना? That is a part third. Huh? Oh, it took it, yeah. Friday.
You sit down and say, your work is.
All right,
Huh?
next Thursday. You ensure one of your junior is there. In any case, I shall say you have received no instructions to make any submissions. है ना?
Yeah, he has received no income, but he has received some material.
Some instructions.
Some like that.
Hey, presence ki nahi lui logo. Heard Mr. K.N. Chaudhary, assisted by K. Das. H. Das, Mr. Petitioner, around D. Das for respondent. Item number 9 and 10, na?
Yes.
9 and 10, and in 11 and 12, PD Nair, huh? For respondent, college.
Cotton.
For respondent, Cotton University, bhi likhi diba. Mr. J. Roy for respondent 7, 8, 9.
And 9-3.
Mr. Das, you are assisted by Mr. Nair in the.
Yes, yes.
And Mr. J. Roy, you are assisted by B. Saha. Heard and heard, and for the hearing, next Thursday, date to date. Interim order is there?
No, no, no. Yes.
Okay.